Okay, so I've already heard from one person that they found the documentary too emotional. Uh, How many of you watched it? Most of you? Not Wax, not Derek. They watched? Okay. So I guess that was you didn't require you don't need to watch a sad movie after that, right? Like um okay. So today's lecture is about something that is a corollary to what we talked about last week, which is the Bretton Woods system. And in the one of the sessions last week, we talked about international trade and the WTO and how that was an offshoot of the Bretton Woods Agreement way back in the 40s, right? So we know that the Bretton Woods Agreement was responsible for um, uh, generating the General Agreement on Trade and Tariffs, and then also the IMF, which is which sort of sees the financial stability of the entire world. That was the mandate of the IMF, and then you have the third leg of the Bretton Woods system, which is the World Bank, right? And so, what many of you may not know is that the World Bank is not just a lender, it is also responsible for arbitrating what are known as investor state disputes. So, investor state disputes are when you have a foreign company, an investor, that goes to a particular jurisdiction and decides to invest. Say we're bringing our money in, right? We're going to give you business. And because we're an outside entity, we want some protections, right? We're bringing this for an investment, but the protection is that we should be given the most favored nation treatment. Has anyone ever heard about this? Yes, Zenith.
Yes, bro. For exceed, for investor state disputes, usually the government's representative would be the Office of the Solicitor General. But in the Philippines, for example, because it requires a higher level of appreciation of the rules of arbitration, we usually hire a foreign counsel for that. So, but however, the trend now is for the lawyers to actually study arbitration, not only international but investor state arbitration in particular, just so we can empower the lawyers and so that we have our own representatives in court.
Yes, so that is unfortunately an issue with not just the Philippines, but also a lot of developing countries. My first interaction with international investment law was when I first went to Toronto. I had never heard about it before that. I mean, this is way back in 2010. So like it you know, I all I knew about international law was public international law, right? So that's mostly international humanitarian law or human rights law or you know how the UN operates, and that's it. And then I got involved with the Ontario Bar Association's international law section. And you have to put this in context for me that uh, as a Pakistani, and then this was post 9/11, this was something that was really close to my heart, especially because there was such a dissonance as to this so-called war on terror, which felt like a war of terror to people, because to us in Pakistan, because it created a lot of security problems for us. It was mostly Pakistanis and Afghans also who died in this, but at the same time, we were being represented internationally as the terrorists, right? So it was, but on the ground, what we were seeing were people dying, and a lot of it was from these suicide bombers. And just to give you a sense of how strange it was, my city, Lahore, is the 14th largest city in the world. It has 10 million people or around that, so a lot of people. But surprisingly, for a large city, we don't have communal riots, and we mostly, it is safe. You'll find the occasional pickpocket somewhere, but I mean, so when the first suicide bombing happened post 9/11 in Lahore, I remember like there was a thread that I was a part of, and I was just like, we were all so surprised, like, why would this happen in our city? And just to give you context, back in the 80s, before the Soviet invasion of Afghanistan, which also created a security problem for us in Pakistan, my mother and my grandmother used to say that they used to go into the canal in the middle of the city, and they could just actually, if they wanted to bathe or whatever as women, they were like free to do this. It was a part of the culture to wear a lot of gold if you were a newly married bride, and that had to change, right? We had to change our cultures, our traditions. It was no longer considered smart to be able to do this, like to show off how much gold you had, or that you were newly married, right? So I mean, just to make you understand, Dodi, it's not just about showing off. It's not for the bride showing off. It's actually for the in-laws showing off that this is how much gold they've given her as well, and also the families, right? And then all of a sudden, it became a stupid thing to do. So anyway, getting back to international investment law, I joined the Ontario Bar Association, and my expectation was that I would be talking more about international humanitarian law, would be talking about all this nice human rights stuff, because that's, we used to get all these trainings from the Red Crescent, Red Cross, the ICRC at the university, at my university in Islamabad. And Islamabad was sort of at the center of the action throughout a lot of this, right? So we sometimes had Colin Powell coming or Hillary Clinton, and it didn't help us that it was also the International Islamic University. So there was like, we were under a microscopic lens. So anyway, fast forward to Toronto, and my expectations are, I get a bit surprised. Why? Because even at the University of Toronto, it's not like public international law doesn't exist, but it exists in a very strange space. And then I joined the OBA, and all of the discussions are about investment. All like the entire, like, because our job was to develop training programs for practicing lawyers, and uh, the focus was Canadian lawyers are often present at these arbitral hearings. They have the advantage of being bilingual in both English and French. So that definitely gives them an advantage in the international setting. And so their discussion is, okay, how do we make things easy for Canadian companies that are going abroad? And if there are human rights discussions, then it's about how Canadian companies are behaving badly abroad. And then how can we, if we feel really badly about that, then how can we make them liable, right? So going back to Zenith's comment, this is all, the capacity issue also exists in other developing countries. It's for sure exists in Pakistan. Despite the fact that Pakistan was actually the first country in the world to sign a bilateral investment treaty with Germany, and the consensus seems to be that Pakistanis did not know what they were doing when they signed this bit, right? And then that bit with Germany sets the precedent for these other international these bilateral or multilateral investment treaties. And the funny thing is, there is no lawyer in Pakistan who knows how to deal with any arbitration or litigation that is related to these bits. And the government definitely doesn't have any capacity. And so what they end up doing is, like, one of the first times that any lawyer gets hired for this, there's a very famous lawyer from Karachi called Makhdoom Ali Khan. You can actually search him up. And even though he's supposed to be one of the biggest commercial litigators in the country, when the government calls him to help them out, he says he doesn't have a clue. And so what they do is their law firm ends up just like Googling and trying to figure out what is a bilateral investment treaty, right? Before they actually go before ICSID and start arguing Pakistan's case. And so even at this point, there are very few lawyers who will have expertise in this. And one of my former bosses was an expert, but he's a funny person. And sometimes what happens is that these big law firms, because they're making money from these big companies being present in the country, they actually don't want these investors to go away because they're getting paid thousands of dollars. And so law firms will actually sometimes have an adverse, like there will actually be a conflict of interest. It might be something negative for the country to have this foreign investor stay on if there's exploitation, but the law firms that are representing these companies will want them to stay on. And I know this because I saw this happen. And just to give you some context for this, my law firm that I was working for was representing Tethian Copper, which is a subsidiary of the Canadian company Barrick Gold. And they had an investment contract with the Pakistani government to explore a gold mine in Balochistan, which is often, unfortunately, in the news because there are people who there are a lot of terrorist attacks that, yeah, never mind. I don't want to say India, but it's there's always that, right? And so Balochistan is where this company sets up. It's also where China is setting up its economic corridor. And so unfortunately, there are a lot of Chinese engineers that end up dying as well in this. So there are security concerns at that point. And then at the same time, Barrick Gold is in a tussle with the Pakistani government. They understand that this is somehow not beneficial for them in the long term. And so the Supreme Court of Pakistan decides that they don't want Barrick Gold operating. Barrick Gold goes for international arbitration, and Pakistan ends up having to pay $6 billion, which is more than Pakistan's capacity at that time. And guess where my law firm is in the middle. My boss tells me I have to research, and so he's trying to, Barrick Gold wants to go away, and he wants me to research that, go and find out what are the tax exemptions that are being given to Chinese companies, so you can make an argument that Pakistan, you can definitely stay because the Pakistani government is being discriminatory towards China, and has a bias against this Canadian company. And so I spent hours and hours finding the right tax regulations, tax exemptions that the Pakistani government was giving to the Chinese, until, as you later on realize what's happening. My boss just wants the company staying, right? So this is, it's funny how it works. And then you see him getting invited to all these panels about how what needs to change about Pakistan's legal system, and why are we so behind? And
May I say something
yes,
about the reason why there are almost no lawyers who are knowledgeable in international law and trade business law? I read it in a book published by a Filipino on the on the UNCLOS proceedings. And the reason why there's no expertise in Pakistan or in the Philippines and many other developing nations is that there is no literature, no publication, not very much. Unlike in the United States, in Europe, the scholars are producing, they're churning out
There
literature.
is now scholarship, which is called Twale Scholarship. Yes, Twale. And I just realized this is, yeah, third world approaches to international law. And you'd be surprised, Singapore is actually the lead on this. They have, I mean, the National University of Singapore has leading scholars like Anthony Angie, who have been spearheading this. There's also, his name is Sorna Raja. He's like an Indian Singaporean who has written books on international investment law. And luckily, my advantage at the University of Toronto was that my professor, David Schneiderman, actually believed in these third world approaches to international law. And the convenient reason for this is that unfortunately, Canada is often at the receiving end of the US's bullying. But so so I mean, it's interesting that you would have Canadians actually be interested in this because Canada was one of the first countries that actually had the money to be able to fight the US, right? And take a stand. So you'll find some Canadian scholars like David Schneiderman, you'll find these Singaporean scholars who talk about specifically international investment law. And so to international law. And so what that means is that the students of these professors were, at the time that I was studying international investment law in Canada, the situation was really dire because the problem at that time was that these investors come, they exploit natural resources, they're responsible for human rights abuses, and you can't make any argument against them in these arbitral proceedings because the 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 developing countries don't have good enough lawyers, and the arbitrators could also potentially be biased, and you don't really know what's going on, right? By the way, you can actually now watch a lot of exit proceedings on their YouTube page. If you go there, if you want to go through that, like it is, some of them are available, so that actually helps you. But what has changed over time is that not only do you have the students of these Twale scholars graduating and going on to have the skills to argue in these arbitral proceedings, you also have developing countries like Morocco having a really good team of arbitrators. They've put their money into this. There are also some Latin American countries. And so they're now able to make arguments, argue that, you know what, just because this investment has happened doesn't mean that it should continue, even though it's a valid contract, because the cost benefit, the cost for this as a country is too high for us to bear. So that is definitely changing.
Ma'am, this one is a movement, right? But where is it based, this one, Twale?
Twale is kind of everywhere.
Everywhere.
It's
There's no, the one who governs
no, I mean, this is just an approach to international, like
it's
it's
like a
just like
movement.
an approach to legal scholarship, right? So you have streams within legal scholarship. I mean, funnily enough, there are even places within foreign universities that are known for it more than others. For example, the SOAS, the School of Oriental and African Studies, has a law school. They're known for this in London. Um, yeah, I mean, the amongst universities in Canada, you have the University of Toronto, but also Osgoode Hall. is like the third highest ranking law school. So you have some places which have more professors and are more open to this than others. Um, but it there isn't any centralized authority that is governing this. Yes, Zenith.
I would like to promote our office. We provide trainings.
You actually provide.
We provide trainings for international arbitration. We'll have ICSID this year. I can send the link once it's available. Thank you.
Please. Dali ako.
There's just to add to this, you have other places like we know that there's a Singapore International Arbitration Center, but there's also their approaches. They're now so Tashkent in Uzbekistan also has an international arbitration center. They have a really good team of government
You
lawyers
don't have to
actually.
be a lawyer, right? To go get into arbitration.
No, 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 not always. You can actually there. I forgot to ask Louis from the other cohort. He knows you can actually get certificates here in the Philippines for yes, Senate.
So for the practitioners here in the Philippines, it doesn't require being a lawyer or passing the bar. However, it really depends on the parties. If they want to have the arbitrator as lawyers, they would stipulate it in the agreement. But there are several training institutions here, like the Philippine Dispute Resolution, and also there's one in Singapore, Singapore International Arbitration, and
SIAC.
the Chartered Institute of Arbitration in UK. So those are really good institutions which provide
Yeah, we
training.
want to support our my BL in case we make it.
Yes, and that actually puts you in the perfect position because I mean, a lot of you come from really technical backgrounds, right? And so you've already read some of the environmental cases. You know that there is more than just law involved there, right? The lawyers must have been super confused when reading those cases. That's not exactly what they signed up for, right? Reading about these different elements, right? But there's always a place for this. But yes, capacity is an issue with developing countries, even their private law firms. Like I remember, I know I'm veering off the discussion a little bit, and I'll get to this. But you know, just to give you another idea, in Canada we have um, uh, like you have in the States, you have Wall Street. In Canada, we have Bay Street. And uh, I was looking to get employed once upon a time over there. And I had a mentor who invited me to what are known as the Seven Sister law firms. And he was working for one of them, and he took me to his office, had me meet the different teams within the law firm. And I know that some of the big law firms in the Philippines are a bit bigger than the ones in Pakistan, but for Canada, if you are a large law firm, your minimum team starts at 100 lawyers. 100 lawyers, right? And can sometimes, even within an office, go up to 500 lawyers. 500, yeah, yeah, yeah. So just within a jurisdiction or even within the Toronto office, you can have that many lawyers. So a medium-sized firm in Toronto is 50 to 99 lawyers. It's a big number, right? For the Philippines, it's definitely a big number for Pakistani standards. And he introduced me to the firm's real estate practice. And so my first question was, how is real estate for you guys different than real estate for the regular real estate lawyer? And his answer was, we sell mines. so, so yeah, mines like nickel mines, potash alum mines. There is an entire real estate industry that is just for the mining industry that I wouldn't have known about had I stayed in my cozy Pakistan environments, right? So it just expanded my horizons as to what these firms are doing, right? And so what I often say is that empires are made by lawyers and the laws that these lawyers create. So there's actually a book by a professor at Columbia Law School. Her name is Katharina Pistor, and the book is called Codes of Capital. Katharina Pistor. So Katharina with K. And she talks about how lawyers have been central to making the West what it is, right? They've drafted codes that have enabled these dominant countries uh, to amass as much wealth as they can. And so the contracts that these lawyers create are really at the center of their development. And so what's lacking, the flip side of this is that uh, in uh, in countries that are not developed, you have weak property rights, weak contract enforcement rights, right? And so that leads to financial instability, economic instability. And that's why people don't want to invest in these countries, or even, it doesn't even, you don't even get locals wanting to do business because they don't know what's going to happen from one day to another, right? So regulatory risks are really at the center of countries of a country's development. So let's move forward. I know I'm teaching ethics, by the way, but you can actually find bootleg copies of Codes of Capital online, and there are also podcasts that Katharina Pistor has spoken at. You'll find her scholarship just generally very interesting. That's also one thing, right? Like the University of Toronto spends a lot of money acquiring books. Harvard and Yale have some of the largest book collections in the world. And so literally every book that gets published is either at Oxford, Cambridge, uh, Harvard, Yale. In Canada, it's Toronto. There are several libraries at the University of Toronto. And the central library, which is Robarts, is 11 stories. It's 11 stories. And that's the one that's accessible to the public. The one that's not accessible to the public, which is Downsview, is even bigger than that. Right? So just imagine, like, not just having scholars, but also the, having access to knowledge is very, very important in these jurisdictions, which was the opposite end of me being an academic in Pakistan at one point. I couldn't get access to books. It was incredibly difficult, right? So there are so many things that are, and that's the same thing with law firms that are researching. Not only do you not have scholarship, it's very difficult to access scholarship, right? So there's that. Anyway, let's get into international investment law, right? So I want you to consider a scenario which is somewhat similar to, not exactly the same, but somewhat similar to the scenario that we find the protagonists of our documentary in, which is there's a government that implements a new carbon emission standard. And this government happens to be a developing country. And this new carbon emission standard effectively shuts down a coal-fired power plant, which is owned by a foreign investor. The investor initiates an investor-state dispute settlement proceeding at the World Bank, claiming $500 million in damages, right? What are the competing interests at stake? What should you do? Yes, Alex.
Well, first is the interest of the investor who made the investment, the coal power plant. Then there's the interest of the government. Also the interest of the citizens of that government, their right to to health and environmental protection, and probably the interest of um, those who are involved in a treaty that came up with the emission standards.
Okay, good. Are we all in agreement with Alex? These are the stakeholders? Okay, so what should happen? You've already watched the documentary. What is the ideal situation? How should international law balance investor protection with environmental regulation? I know Alex still wants to say something. Dodi?
I think the sustainability principle should be in the law also.
It should be
protect-
there?
Yes, ma'am.
Okay.
Because sustainability does not only protect the environment, it also draws the rules or defines the rules that will also protect those who are in business.
Okay, you'd be surprised to know that until recently, most investor state treaties did not have any environmental clauses in them, did not have the environments or even human rights as a defense. So very few investment treaties that have labor law clauses in them or anything of that sort. So it's not like it's not there, but a very recent development. So most likely, if you are a developing country, you're stuck with a treaty that doesn't have this as a defense. And so the drafters are also going to be people from the developed country. And so a lot of times you'll have people from the lawyers or the teams from developing countries not even having the capacity to counter at negotiations. It's definitely a problem for a lot of Pakistanis. They, the cultural communication standards are different. The soft skills are different. What is considered okay in Pakistan might be considered rude in in other jurisdictions. There is a language barrier, which I know Filipinos don't have a problem with a lot of times, especially if you've had a certain type of schooling. But this is a real concern for a lot of developing nations, right? Unless you have economic power to back you up, like the Chinese, right? Um, where just the name is enough, right? So I mean, that hasn't been overnight for China. Until China entered the WTO, this was not the case, right? So it wasn't overnight. There were policies in place that made China the way it is, right? So these are just to get you started. These are some of the stakes involved. Now let's look at the law itself. What is international investment law? What is it all about? And what are we dealing with, right? So it's a system of rules, treaties, and institutions, including ICSID, that govern the protection and promotion of foreign investments. Mostly these foreign investments are coming from developing countries, right? Unless you have outliers like Brazil, which want to buy nickel mines in Canada, so you'll get the outliers there, right? So you'll have what's included in international investment law is bilateral investment treaties, investment chapters in free trade agreements, and then also on the institutional level, you have the investor state dispute settlement mechanisms, which are governed mostly by ICSID, and ICSID has its own arbitration rules. that you have to follow if you're going to arbitrate through ICSID. So what international investment law focuses on, and these rules have obviously been made by the investors, is to protect uh, foreign investors against expropriation from host states without getting fair compensation, right? That international investors should also be given fair and equitable treatment. And this can be construed in many ways, right? Some of the older it's so funny, the language of some of these older treaties, because there was and some of the older treatises on international investment law, because mostly the investors were from civilized nations and they were investing in civilization, like in countries that were uncivilized, right? So just expect that when you're going to these countries, expect there to be no rule of law, right? And so you have to use brute force, and you find examples of things like the pastry wars. Sounds like something that you would fight over your brothers and sisters with, on the weekend. Maybe somebody's thrown pie at somebody's face, but no, actually, these are wars that happen to in Latin American countries to protect bakers from these civilized nations from expropriation from outside. So entire countries were destroyed to protect these bakers, right? So there's that. Then we have at the very end the national treatment and most favored nation clauses, which also exist in international trade law. Yes,
I have a
Jody.
question on expropriation without compensation.
Yes.
Uh, so it allows expropriation, meaning that it is allowed, but there should be payment of compensation. Is that it?
So
Or is
yeah, I mean, because you don't want to say that the host country has no sovereignty, right?
an attribute of sovereignty?
Yes, right? Sometimes the government will say that it is in our country's like the public interest of the citizens of our country that you no longer operate. And if you resort to something like the pastry wars, then you are effectively invading the country, right? And nobody will like to do business with you, right? So the best thing in those circumstances, which is something that corporations will take at the very end, there'll usually be these long litigation battles, is to accept compensation, right? Okay, so I hope that answers your question, Dodi.
Yes, ma'am. Thank you very much.
Okay, so the last thing is national treatment and most favored nation clauses. So what this means is that if you have a foreign investor coming to a host state, you are going to treat them exactly like you do the indigenous business people. And you are going to give all foreign investors the same treatment.
Ma'am, in there, I have a question because I think I saw that in one of the readings that most favored nation treatment or clauses pertain only to members of the WTO or
Yes, in international trade.
International trade.
In international trade, in international trade law, but in international investment law, it's this is for countries that are part of the multi of a bit of a bilateral investment treaty, or are all investing in the same state. So it's the scope is a bit broader technically than WTO. So for the most favored nation clause in the WTO context means that you are giving all members of the WTO the same treatment, and that you are also giving them the same treatment as companies from your own jurisdiction.
In international investment law, that is not the case.
In international investment law, what this means is that you are giving all foreign investors the same treatment. So you're not giving one preference over the other, right? So in the old days, what used to happen was that a prince would get married from another prince, from a princess from another country, and so you would definitely have a most favored nation treatment over there, right? This is what all those stories are about, actually, guys. Don't listen to Disney. That's what's really happening. There are trade deals happening in these stories. So that has changed with international investment law, right? Even if you get married to a princess or a prince from another nation, all that's going to do is secure your own personal wealth, not the wealth of your country. If you tell the story to your kids, they will never watch Disney the same way again. Okay. So leading up to Doty's question, just follow up on that. Investment and trade law are closely intertwined, right? Why? Because foreign investment, just like international trade, requires cross-border movement of goods, services, and capital. And then also you can have provisions in investment treaties that have significant trade implications. And these they can also have investment implications as well, right? So you can have market access commitments in investment treaties. You can have MFN obligations. And then sometimes there can be overlaps in dispute settlement mechanisms. And I'm going to get into how some companies will deliberately do forum shopping. If they don't get the response they want from ICSID, they will go to WTO by asking their governments to basically start a dispute against the other government at the WTO. So if they have enough power and money, they can do this. Okay, so bilateral investment treaties can also have both investment and trade related provisions. And like I mentioned, their purpose is to protect and promote foreign direct investment and create a stable, predictable investment environment, thereby encouraging cross-border investment flows, right? Sometimes, so amongst other things, this is like not very clear. I just realized that, but they'll also have transparency and environmental standards, safeguarding the right to regulate, dispute resolution procedures, fair and equitable treatment, protection from expropriation and compensation, and so on and so forth. Okay. A step up from bilateral investment treaties are multilateral investment treaties that have more than one country, more than two countries involved, right? And they will also establish common standards for investment protection amongst all signatory nations. And the parties can be more than two, right? At the implementation level, you'll have they'll also require domestic legislation to implement the treaty obligations across the member states. We've already covered this. Yes.
I noticed in the previous slide that there was it says their implementation often requires domestic legislation to implement treaty obligation across member states.
Yes, so it
There
needs to be
must be,
applied at the local level.
it must be a transformation into, we call that
Yes.
transformation. If there is no local law that corresponds to to the multilateral treaties, then it is not effective in the something like that. Just like in the criminal international criminal law.
Ideally, no, but sometimes you have these corporations still pushing forward. I mean, there are, it's definitely getting better for sure in terms of national sovereignty, but the beginning of international investment law was not that friendly to host nations, if that makes sense. I mean, just
Oh.
think about it. Just think about it, right? Yes, Jody.
It is the provisions of the treaty that will govern. Let's say it says no need for local legislation that will correspond to the bilateral
Yes.
treaties. Then it
We
will
do have treaties that actually say that the implementation is immediate. Yes.
So if I'm getting what Dodi is asking, it's about the enforcement, for example, of an award
Yeah.
in the Philippines. So if it's pursuant to an MIT, then and a certain country, for example, won the award, and that's Philippines. We actually have a mechanism here in the Philippines that it would be simple to uh, enforce it at the regional trial court level, and that the regional trial court cannot can only refuse to enforce it or enforce it, but it cannot be overturned. So it if the question is, do we have to have a local legislation on the enforcement of an award, on the aspect of enforcing an award, it's not required anymore.
So you're saying, Attorney Zinit, that if there is a judgment or a ruling or an arbitration award in another country, or an arbitration award, to enforce it in the Philippines would need the assent of the judiciary, correct? Would that be accurate?
Mhm.
For enforcement, I think
Assent of the judiciary. I would say that it's quite mandatory, except if there are violations of public policy.
Yeah. I mean, it's
yes.
normally the state has to implement this
Yes, ma'am.
if it's an international award.
Yes.
AJ wants to say something, I think. This thing. Yeah.
Okay, I'll share it. Okay. First, I would like to answer my colleague from the Senate. I would say before the implementation, most of the international funders, the contract formation is actually composed sometimes in FEDIC, which is in France, sometimes NEC contract,
Sorry.
NAC contract.
Mhm.
Sometimes it's a bespoke contract. So most of the provision of dispute or implementation is addressed on a legislative, on a dispute in Singapore, Hong Kong, or UK. So the domestic legislation sometimes is just the local governance that should be aligned. But the implementation, actually, the implementing body is what the contract formation dictates.
And just to add to that, it also depends on what the host state already has in place. So there are some host states that are super vigilant about this. Uzbekistan, for example, has model contracts that you can find on their government websites that they encourage investors to follow if they're going to do investments in Uzbekistan. Not every country has this. Pakistan, for example, doesn't have this. But again, that's more of a jurisdictional capacity thing. I don't know how it is in the Philippines. But I've definitely seen, like, for me, that was also something really surprising when I was in Uzbekistan, in Tashkent, where they have some international law firms like Dentons and White and Case And there was a conference that I was attending, and they had a a leading government representative coming and basically bashing all these Uzbek lawyers who were partners at these major law firms and telling them, listen, we already have these contracts. You don't follow them, and then your clients get into trouble. And then all you're looking for is money, but just follow this, right? So, I mean, I'd never seen anything of that in Pakistan. And so that was a surprise. But yes, Janet.
So in the Philippines, Prof, we also have model contracts for investor state disputes or model clauses for other types of arbitration. But the problem is usually, as AJ already said, that during the contract formation stage, sometimes it's more of the interest of the lawyers have a crucial part in the drafting of contract. So sometimes they would it's they already know what the language should be, language or tone of the contract be, but their personal interest would come into play. Like they would prefer to have a dispute or to have a very vague contract. So there's also that kind of factor.
Yeah, sometimes you'd be surprised. Even the government wants to have disputes. Yeah, yeah. There are
What's
government
the
employees who make money from disputes. This is a thing with the national energy regulator in Pakistan. There have been disputes that have been going on for around some of these solar power projects. And I know somebody who has their legal team, and I was like, what's going on? And she's like, that's because NEPRA roundabout in a roundabout way was people at NEPRA were making money from these disputes. So I mean, it's funny how that works.
I thought that
Yes,
law was not a business, ma'am. It's a profession. It has been repeated in the Philippines that law is not a business, but the way they're acting, they look like they're
but again, that's a
running a
mindset problem
business.
because again, when I was involved in the Ontario Bar Association, it was very clear to the Canadians that law is a business, and they used to have these MBA in a day programs for lawyers that was just around the fact that lawyers don't know how to keep their own accounts. We would have events on how to network. It very much is a business for lawyers who, I mean, in Pakistan also, the founder of Pakistan, Muhammad Ali Jinnah, was a lawyer. And so, I mean, it's considered to be the noble profession, even though lawyers are the most ignoble of people in our country. But, that's the ideal. We all want to be Muhammad Ali Jinnah. He was such a fantastic lawyer. He made such a great case. He never lost any, like, he was also he made a lot of money as well, right? But the truth is, it is a business. Yes, AJ.
Just to add on an correction on the implementation. Actually, although all those contract formation and easy contract, FedEx contract, and bespoke contract, and Filipino lawyers contract formations have a provisions of arbitration. But prior to arbitration, there's a dispute resolution called mediation process. So that mediation process, the local can be a governing rule
Yep.
during the mediation. Once it's not settled, there are conflict already and it cannot be resolved. That's the time that it has to go to arbitration where the contract is dictated mostly for FedEx and NEC contract are in Hong Kong and Singapore and UK.
This is more of this is usually what's happening mostly when it is more private parties that are arbitrating rather than a state. But that all just goes down to the contract, the enforceability. There are some jurisdictions that allow foreign laws to be used in their own jurisdiction. And so it depends. Really just goes down to the power of the contract, and where you can actually get that contract enforced. So if you were listening to a lawyer and you had like two private parties disputing, then they would say, really look at whenever you're drafting the exit clauses, right? Really look at where you can actually get the contract enforced. Just be really practical about it. So it just goes on to that, but that is not investment law, that is more the domain of the International Chamber of Commerce or the different chambers of commerce. But it is what it is. I hope that helps. Yes, Derek.
Hello, Prof. Just curious, like, I mean, in terms of that, those cases, between the, we call it developed investors with those developed countries' government, cases that they, I mean, they sue those, developed countries because of the changing laws and they had damages of their losses. In those cases, which parties win? I mean, in your perspective and in your cases.
Depends on the strength of your team. Yeah. But you know, the thing is, it's funny how some of these arbitrators will also be acting as lawyers for some parties in other cases. It's a very close knit group of individuals that know each other, and so sometimes they'll be acting as counsel, sometimes they'll be acting as arbitrators. But the short answer is have a good legal team. Yes, Alex.
Oh yeah, dispute resolution. This is one of the most contentious clause in contract negotiation. So probably 10 years ago, most lawyers would just ignore this provision. Now this is the most red line. So especially when we're dealing with multi-location parties. Take for example, if we're in my company, if we're dealing with a U.S. company, they would insist on New York as a venue for arbitration. For Southeast Asia, it's Singapore. And the seat of arbitration, meaning what particular law governs, that's very contentious as well. People who prefer Hong Kong, or and yeah, Canada is also a good place to arbitrate or negotiate. So I think I agree. You have to have good lawyers because uh, all of these are in place during contractual negotiations. So it has to be agreed upon. And there's a strategy involved depending on where your parent company is. So if I am from the Philippines, I would insist on Singapore as a middle ground rather than, mediating or arbitrating in the US or in Chicago for that matter sometimes. I would push for it's a non-negotiable to have an arbitration clause that provides for Hong Kong or Singapore.
And I mean, you would know even at that time what the other party is like, right? When you're negotiating. If you really want to go forward with this contract at all, right? Yes, AJ.
Just to answer to my mate here, Derek, actually, you don't hire lawyers. For a dispute or conflict, you hire a forensic delay analysis before you go to arbitration because that's clause 19 already. So there's a resolution of clause 8.3 to make reconciliation, how to meet in the middle to avoid conflict. So that's a mediation process.
Yeah.
So if you require one, I have a company in Singapore that will push you. And the good thing, Professor, China State Guangzhou Construct, I'm actually their forensic delay analysis. Just for your information.
Sorry, could you repeat that? China's.
China State is one of my clients,
Right.
Guangzhou Construct, all those Chinese companies who have conflicts here in the Philippines with contractors. They don't go to arbitration. They go to a delay analysis.
Yes, yes, go ahead, Derek.
We don't have conflict in Philippines. We have conflict in Vietnam.
Just in
Vietnam,
case in
yes.
future. Just in case in future.
Right. I mean, just in general, as far as legal practice is concerned, there are very few cases that will go to arbitration or a step further if you want to go to litigation. There is actually something that most commercial lawyers will now even focus on, which is called discovery. Have you ever heard about it?
We have it in our rules, I think.
Yes, Zenith.
This is the production of evidence or the manner of it, which specific evidence is allowed to be produced.
Yes, and that goes to what AJ is saying about forensics. That is actually the work of a lot of lawyers. That's also where a lot of outsourcing happens, yes.
It's not actually lawyers, it's construction lawyers. They're not really the Filipino or Singaporean lawyers. We are called construction lawyers. FedEx background and an easy contract background.
Right, of course, you have specialists in the field, right? And so depending on the field, in this case, construction, you'll have that. Sometimes you'll have those real estate lawyers that I was talking about, right? Depends, right? So yeah, I mean, most cases will not actually go to this, like they'll just be at the table talking about what actually happened. Because the thing is, at the end of the day, with these contracts, you're doing business. And it's not just about winning the dispute, it's actually about making your business work, right? So the best thing to do is document everything so that it's all clear. Zenith, you wanted to say anything? Okay. So let's move forward to the very emotional documentary that you guys watched, right? What were the key takeaways from you from that documentary? Yes, Zenith.
Prof, one of my key takeaways is how, although arbitration really settles dispute fast or in a speedy manner, sometimes it fails to really address the social justice part of it. It fails to humanize the process, or it fails to really go to the victims of the victims or the people involved in the case.
Yes, KB.
Similarly to the Rhino case, Prof, the real stakeholders of the problem were not well represented.
They didn't have the right resources, the right contacts, right? AJ, did you watch the documentary? Did you have anything to say? Nothing much. Okay. Yes, Senate.
Prof, there's one part of the documentary wherein the woman was talking about the problem regarding confidentiality in arbitration processes. And as we all know, arbitration proceedings are confidential in nature. There's no way that we can access it during the proceeding, even if we're under Senate inquiry, for example. So on surface level, I understood the concept, and even if I was on handling arbitration cases, I would always accept it as a matter of fact. But when I watched the documentary, I realized the impact of the confidentiality of arbitration proceedings, because sometimes people just want to know what really happened. They just needed an explanation. And when it's gone through arbitration, there's no way for them to know
So
it.
it was very personal for you on that level.
Yeah.
Yes, Alex.
One of my key takeaways is that not all parties are actually represented in arbitration. It's very commercial. The approach is very high level. When I saw the actual stakeholders were really affected, um, it's an eye opening. Uh, for me, especially whenever I participate in arbitration, I only think about the main parties. I never take into account that um, those there are people who are affected by major business decisions that involve the state and investors. We only see numbers, we only see how much the damage was caused, but as to the human that it was at least in my experience in one arbitration case, the human element was never discussed. It's mainly financial and commercial.
So if you would revisit that case, what you have done differently now?
I would have taken into account the small parties or the small stakeholders. I think everyone should be involved, whether big or small. I would have taken that into account and put a value to it. Unlike in this particular case, there's a human value to them losing their homes or being driven away from their where they grew up. Largely, those are almost they're like ancestral lands, and here we have a government, we have a big mining company coming in and taking that away, and that was never factored in the decision of the. Well, there is a discount that was given, But it was not mentioned in the documentary what the 30% discount is for. It was never stated that it's for human rights violation. So yeah, I would have looked into that detail and then put a value into it.
I would give the indigenous group, or the indigenous, though the small group, a chance to say something on the stand, Prof. Because I believe their opinion is very, very valuable to this case.
So who would you blame for this? For them not having a voice?
I believe it's the government, Prof, because the government should actually not just be only to protect the interests of the government of the nation, but they should include these people as well.
Zena, what would you say to that?
Yeah, I would say that if had I known that that would happen, for example, I would have drafted the arbitration agreement giving credit to fairness, because as a general rule it's not included as a standard. So maybe the parties could have included that, so that it would have given weight to the people in the local communities.
So I'm assuming that doesn't happen at this point with the DOJ.
In the no, because we don't have to include it in the Philippines, because we already have the civil code, an article in the civil code which actually promotes fairness, act with justice, blah blah blah. But the problem is not all arbitrators and lawyers know how to trigger that provision. So as a general rule, people would think that there's no fairness standards in arbitration proceedings, but there's actually a workaround on that. So if you trigger the provision under the Civil Code of the Philippines, fairness would be a standard.
Okay, Alex and then Carol.
Well, I think the issues, well, during arbitration the issues are being discussed and agreed to, and there was an attempt on the part of the government of Ecuador to present these witnesses because they were made to fly. But I think something happened during the arbitration proceeding that made them exclude those witnesses. And I fault Ecuador for that, precisely because maybe that wasn't part of the issues that were raised or agreed to by the parties during the arbitration proceedings. And it appears that it's the mining companies, lawyers, or whoever is representing them in the arbitration won by excluding these pieces of evidence because the witnesses, the members of of that community were not made to testify, and human rights violation was not made a central issue, I think, of the arbitration. And the sad part is they do not understand that fact. The community did not understand that it's a technical matter. They became a technical matter when they were excluded as part of the consideration in the arbitration award.
Okay, so the mood is super grim. Well, we know that uh, we can understand now after watching this documentary that uh, their human beings are more than technical matters, right? And sometimes when we displace people, they'll never ever have the resources to come back and settle down again, right? Especially if somebody's living paycheck to paycheck or just doesn't have the resources. Okay, so what are some of your options for reforming investment treaties and investor state disputes settlement to align with climate goals? You can take the broader international route and also see what you can do at the local level. Yes, Senate.
Prof, I believe that the most impactful change should be government sanctioned, which means that the recommendations, the alignment should be on a government level. Although the normal people, normal groups, NGOs, for example, can propose, I would normally recommend that it undergoes like the entire process wherein the president of the Philippines, for example, can sign off on that.
Thanks. I know Zenith is like super involved in this, right? So she's right in the middle of it. Uh, she added me to her LinkedIn. So she sent me an invite, and so whenever go into LinkedIn, I see Zenith talking about exactly these issues. So I know this is very personal to her. Um, okay, so let's move forward. Right. So we know that there are problems. We also know that we have these big companies that are responsible for these problems, right? Like this, it's profit over everything else. And then we've also discussed how they can even do forum shopping. And one example of of such an investor dispute actually has to do with cigarette packaging. So have you ever heard of Philip Morris? It's a cigarette company. So there were restrictions on Philip Morris over how they were packaging their tobacco in Uruguay. And so they were actually required to have like blank packaging, not, or you know, sometimes these countries will also have restrictions on how you're advertising cigarettes. So when I was young, in Pakistan, a lot of these cigarette ads would be like very James Bond style ads, right? If you smoke John Player, you'll get the woman in the red dress, right? Uh, where in real life you might actually run out of your lungs and not be able to even talk, right? Let alone run like James Bond. So uh, it's true. My dad is a smoker, so I have a personal gripe over this because we've always been trying to get him to quit unsuccessfully. But anyway, so Philip Morris files an investment treaty claim against Uruguay. So Philip Morris is actually a Swiss company over the restrictions on tobacco packaging. And um, there are other trading partners, such as Honduras and the Dominican Republic, which later initiate a WTO dispute against Uruguay's tobacco control measures as well. And so Philip Morris decides to
He likes James Bond.
yeah, just imagining him huffing and puffing after this.
Not finished imagining the how James Bond was chasing.
So yeah, so I mean Philip Morris loses a bit, loses at the arbitration, the investor state arbitration, and then decides to go to the WTO. Guess what happens? Actually, they lost the case because it was found that they were forum shopping. But in some cases, you can actually say that, you know, there is, if there's a good enough case that,
So the ground for the dismissal is no, is forum shopping.
sorry?
The ground used by the second forum was that
Yeah, if you
forum
if-
shopping.
lose the arbitration at ICSID and then you decide to ask your state, hey, Switzerland, I lost the case, but I have a lot of money that I'm willing to pay you. So you can take my revenge for me at the WTO. I will make you wealthy, right? And actually, this is a matter of national pride and sovereignty that we promote Swiss cigarettes in the entire world. And so Switzerland says, okay, Philip Morris, I will do it, right? I will say that the government of Uruguay is being discriminatory against us at the WTO and is violating the rules of the most favored nation principle, right? So this is definitely a possibility. Sometimes you will see corporations that lose the environmental arbitration, then going to the WTO, saying that, you know, this was, they'll make some sort of technical argument using their, you know, state, the state where they've registered as a corporation to go against the developing nation. So it's a possibility. Right. So for host states, this is if you're entering into these bits, you really have to balance out your regulatory autonomy versus also giving a stable environment to your to your investors, but also take care of your stakeholders at home. um, sorry. So sometimes even developed nations can fall victims of this investor state dispute fiasco, to say the least. Now, we know that Fukushima happened in Japan. That leads to the collapse of the nuclear power industry, the nuclear energy industry, right? Which also, I told you about my contact in Toronto who used to be a nuclear engineer, used to build nuclear power plants, and he finds himself out of a job, right? So Germany decides to phase out of nuclear post Fukushima. And then there's a Swedish utility company called Vattenfall, which is operating in Germany and decides to bring an investor state dispute against Germany, right? And the argument that Vattenfall makes is that it had a 32-year license, and so it had a legitimate expectation that it would be allowed to operate for at least these 32 years, right? And that there are domestic companies that are being allowed to operate, but Vattenfall is a victim because it's an outsider, right? So it's not getting national treatment. And then also the last point is that it is the money that has been given as compensation is inadequate for it to recover its losses, right? So this costs Germany quite a bit, right? And what it does for governments is that on the receiving end of this, they have to think twice before enacting policies, sorry, which they know could be beneficial to their people, but will harm them monetarily as a whole. The Philippines has also sometimes found itself in the middle of this. So there was actually a corruption case related to Naya Terminal 3. And in this case, it was a German company that was the investor. Now, there were a lot of issues with this Terminal 3 investment. There was a political change that was going on around the same time. There was one government who invested, and then the other government didn't want to do it. And so that was also an issue. But there were also environmental compliance issues as far as the German investor was concerned. And then as far as I know, I was not there. Maybe you guys can tell me, there was local opposition. Did you ever follow this case, Dodi, or anyone else?
I heard it reported in class, but I was not the one assigned. It was my classmate. So I reported on barangay justice.
Right.
I think anyone? I'm not familiar, ma'am, with the
Yeah,
the
this
general.
also eventually led to a WTO dispute as well, but you guys will probably study that when you actually study international trade.
Actually, this is new to me, ma'am.
Sorry?
Actually, these things, yung the angle of international trade is new to me. So, but it's good that I learned the difference between trade and
Investment?
investment. Yes. So now I can see more clearly when I examine treaties. Thank you.
Right. So one of the arguments that Fraport made was that there were no clear environmental standards in the Philippines at that time. And so this actually, oh, thank you so much. Thank you, Ivana. And it's warm too, so that helps me. So, yeah, so I mean, when this goes to the for international for to arbitration, the Philippines also ends up getting sort of a smack on the hand, right? You don't have transparent environmental governance standards, and that makes it difficult for investors to actually operate and do business in the Philippines. So lessons for climate policy on the state level, you need to be more consistent and more clear so that investors know exactly what is going on. Otherwise, you'll have big companies coming and making you liable for millions of dollars, right? So yeah, that's a possibility. If you decide to say, hey, you're not meeting our environmental standards, maybe do your own due diligence as a state. So, I mean, this is like just, I don't want to talk too much about this because this is potentially something that is going to happen. But I'll just leave it at that. Now, Spain has also been on the receiving end of trying to change its, climate policy. And so what it did was it was providing feed-in tariffs to solar providers. Maybe the two solar representatives can tell us how feed-in tariffs work.
Yes, I think feeding tariffs is something that the local government encourage the foreign investors to invest the solar projects in the local, and this is the fixed price that they will give. They will buy your electricity price, and which is sometimes will be by ways of the bidding process.
Yes. So in Spain's case, they provide these feed-in tariffs to foreign investors who are investing in the solar industry. And then what happens is that it actually starts costing the Spanish government to be giving these feed-in tariffs. And so they decide to rescind them. And so that leads to investor-state disputes as well. And they end up paying out $128 million to Eisen Infrastructure, 101 million, euros to Antin Infrastructure. There's still ongoing litigation with Masdar. right? So, yeah, I mean, the point is, before you make a policy or after you make it, just do your risk assessment as to what could potentially go wrong. Um, uh, so yeah, I mean, you could you could lose out on a lot. Um, and with that, I think I will end today's session. And in half an hour, you will be listening to a much more qualified professor from Yale Law School. And she is going to join us at 3:30. Yes, AJ.
Prof, just quick question on the previous slide about feed, feed and tariff.
Yes.
You don't mind try to expound so that we can understand clearly
Okay.
how it's being arranged on renewable projects.
So basically, you get a benefit from the grid that you're operating it, and you're selling it to the government. It's like, Derek, maybe you could elaborate. Yes, Alex.
It's well, in the Philippine context, it's very expensive to put up renewable energy projects. So what the government does is they put a guaranteed price for renewable purchases, and that guaranteed price is usually on a period of 15 to 20 years, so that the investors can reasonably calculate what their earnings will be in the next 20 years and make their investments reasonable. This is also a problem in the Philippines, ma'am. What's happening to Spain because of the feed-in tariffs that entice these investors to come in the Philippines. We have high electricity rates in the country. So I don't know if we can do what Spain did by rescinding the feed-in tariffs. So
Well,
it's yeah.
Spain had to pay heavily for it, right?
Yep.
And I mean, just a funny joke on our side, like the firm I was working for in Pakistan happened to represent one of the largest solar parks in Asia, which was the Qaeda-Azam Solar Park in Pakistan. And when they were applying for this tariff, they made a mistake. And this was, things are not digitized. So they thought they were writing 9 and the government read it as 4. So that ended up going into litigation. The government didn't want to understand the company's point of view, and then the solar plant just ended up ending. Yes, Derek.
Just want to share the cases actually similar like in Spain. In Vietnam, actually they launched the feed-in tariffs 9 US cents per kilowatt hour like 4 years ago. And most of the investors came to the invest, and a lot of the projects happen in place. And last year, the Vietnams, they changing law. They just say that they want to reduce the price to 4 cents something. So now like more than 30 investors from different countries would like to sue Vietnam government, and we are also one of them. Yeah.
And you hope to make big money out of it.
Prof,
Yes.
actually, I have one question, but two of my mates, I would expect that. One is Derek and one is attorney here.
Mm.
About the feed and tariff arrangement, who's the regulatory body who's trying to execute this one here in the Philippines?
It's the DOE in the Philippines, Department of Energy.
On your business and your renewable, who's the governing policy maker?
Actually, Philippines doesn't have the FIT. Philippines is the bidding process. GF.
We have FIT. There is FIT in the Philippines as well.
For renewable energy.
Yes.
Let's discuss
Yeah,
after
yeah.
class. I think.
Actually, we will discuss three of us outside.
Okay.
Thank you, Prof.
Ma'am, just one question on the subsequent slide. I noticed there was a phrase,
Don't sue me.
there's a chilling effect or something like that. Maybe in the last slide.
Yes, this one,
Oh, I
the
think I
regulatory
saw.
chill. Yeah, I mean, basically what it is,
What does that mean in international law? Because we have that here also in freedom of expression cases in the Philippines. But in this first time I saw a chilling effect, was it? Or
yes, I mean, it just sounded nice.
Okay.
But the gist is that um if you don't have the right investor state dispute mechanism, if you don't have the right clauses in your bits, it can lead to regulatory problems, right? So governments, when they're faced with all this litigation, then they become a bit more hesitant, right? When they start drafting,
So that's the chilling effect.
it's the chilling effect. Yes, KB. This has happened to me the second time today in the other cohort. There was somebody who I thought he was, yeah, I just realized afterwards he was just frustrated about something and I thought he was raising his hand. So I apologize. And let's see Nadia in half an hour. I'm super excited to hear her as well.
Prof, she's from Pakistan also. No? Okay. So he's in the US now? It's early morning now. Yeah. Huh?
Um, good afternoon. How are you all?
Sorry, how are you, Nadia?
I'm doing good. Good to connect with you all.
I know it's super early. I hope you were able to get enough sleep. You look tired.
Oh, no worries. I'm doing well.
Okay, I'm happy to hear that. Um, I've already given them quite a lot of information about you, and I've been prepping them for a few weeks. So they're super excited to hear from you, Nadia, about business and human rights. So it's the floor is all yours.
Okay, thank you so much. So first, what I wanted to do is I wanted to start off talking about the development of environmental justice. Is it okay if I do a slideshow?
Absolutely.
Okay, great. So this picture that you see right here, this is of, sorry, just, this is in 1982 in North Carolina in the United States. The person that you see in front of you is Reverend Ben Chavez. He was actually taken to jail with a group of other protesters following the Warren County PCB landfill where they were protesting contaminated soil in their community near Afton, North Carolina. And if you look at this photo here, you can see a racial and multi-ethnic community in a rural area. And so this in the United States was the roots of environmental justice during the civil rights movement when it had started in the 1960s. And here you have a group of people who are exercising their constitutional rights to free speech as well as to peaceable assembly. And so this is also roots of grassroots activism, as well as the consequences of unrestrained technological development that was happening. Because this chemical PCB does not naturally occur within nature. And you can also see that there's engagement of the faith-based community as well in this photo. And so even so, while you have these popular conceptions of discrimination, environmental justice, in the early days, it's not something that can be reduced to a black and white issue. But as you can see from this photo, which is really iconic, is that the environmental justice was never a limited movement. And so for this photo, which we had obtained from the newspaper for a casebook that I work on relating to environmental justice. And so environmental justice really is hard to define. You can't just define it as one simple thing. And even what's interesting is looking at the arrest records of those who were arrested, is that the engagement included both Black and white protesters as well as Native Americans. And so and environmental justice was never really a movement that could simply be defined by a certain race or a class of people, but a movement to ensure that the protection of all people, including themselves. And so it also would be those who would also go on to be your future clients as well in terms of those who are going to be protected. Another case that also developed a lot of attention recently was the Flint water crisis, which happened over 11 years ago is when it was first came to light. And since then, there has been other cases as well. The lawsuits surrounding the Flint water crisis, where you see these violations of environmental laws, led to over $641 million in damages, along with criminal charges that were brought against those who were responsible. And so what happened is that even though there had been clean water that was flowing as a part of out of the faucets, there was a change that was made that led to water that was tainted with lead being coming into the water. And so the contamination was so severe that it had led to over at least 12 people who died as a result of these changes in the drinking water. And also what you would see is that there was maybe dozens more of people who died as related issues. And the settlement claims that were brought out from the state of Michigan and the city of Flint, along with others, could also have civil claims that were brought also against the hospital, along with rural professional services for the water crisis. Even though most of the money is expected to be paid to the Flint residents, there were many young children who they were exposed to the lead. And so the actual impact would take a long time for them to be able to see and observe that. And this is another protest photo. And this includes marchers who are fighting against the Dakota Access pipeline. And what was interesting here in this case is they were trying to develop a natural gas and petroleum pipeline, and there was concern that there could be contamination and exposure to water that was protected, as well as other sacred land that was protected during Native American rights treaties. And so the protesters who were involved with these types of activities, they had employed specific types of tactics. And so there was they used special code names like marmalade and peanut butter to describe the certain areas where they were going to be engaging in specific types of direct action. And they had used these code names because they didn't want to disclose the locations that they were using. And they had also gone to these protests ready to be arrested. And so, in fact, dozens of cars were soon seen caravanning down dusty dirt roads amid corn and soybean fields, where they had seen a large support. And there had also been a specific civil disobedience campaign to try to stop a border crossing, as well as oil pipeline that was running from Canada across the wetlands and forest of northern Minnesota. And so by mid-morning, you could see from here that you had hundreds of protesters who were gathered, and the group had been led by Native American women, was also joined by celebrities such as Jane Fonda and Catherine Keener, and they had marched on the construction site that was operated by Enbridge, which was a Canadian company behind the pipeline, and they strapped themselves to bulldozers and other heavy machinery. The intensifying conflict over Line 3 in Minnesota had also driven in part by indigenous activists who saw that there was a double barrel threat to the pipeline by both the carbon producing fossil fuel project at the time, as well as worsening climate conditions and the risk of water for pollution at the headwaters of the Mississippi River. And some of the protest activities were essentially emboldened by some of the victories. This includes the cancellation of the Keystone XL pipeline, as well as gatherings at Standing Rock. And so the protesters hope to intensify pressure at Biden administration during the time, even though the Trump administration would come in later to approve this pipeline. Another thing that you could also see happening in terms of variations would be gaps in terms of response rates during COVID. So what's important to also see is that that there was studies that were done that linked race and ethnicity to disparate impacts from COVID-19. And so Black and Latino residents of the United States were 3 times more likely to be infected than their white neighbors. And so in the context of the COVID-19 pandemic, risk assessment revealed clear disparate impacts of the disease on population segments, including the elderly and racial minorities. The Centers for Disease Control and Prevention reported in its report on COVID-19 that health disparities were impacted by environmental factors as well as living conditions. And so there was a group of interrelated factors that could be used to discuss how illness and results resulting from COVID-19 were occurring because of comorbidity factors. And so the effects of COVID-19 on health and social and ethnic minority groups was still emerging, but a lot of the current data showed a disproportionate burden of illness and death among racial and ethnic minority groups. And there was also a report that had been done by the Center for Disease Control that also showed data from 580 patients that were hospitalized and had lab confirmed COVID-19, and found that for 45% of those individuals for whom race and ethnicity data was available were white, compared to 55% of individuals in the surrounding community. And also approximately 33% of those who were hospitalized were Black, compared to 18% of the community, and 8% were Hispanic, compared to 14% of the community. And so this data also suggests that there is an overrepresentation of Blacks among patients who are hospitalized. And also among the COVID-19 deaths for which race and ethnicity data was available, New York City identified death rates among Black and African American persons around 92.3 deaths per 100,000 population, and Hispanic and Latino persons of 74.3% that were substantially higher than that of white, which was 45%, and Asian, which was 34%. And there's also studies that were conducted to confirm the data and also understand the potential to reduce the COVID impact on different racial and ethnic minorities. And so what's interesting is that the health differences between racial and ethnic groups are often due to economic and social conditions that were more common among certain racial and ethnic minorities than in whites. And in public health emergencies, these conditions can also isolate people from resources that they need to be able to prepare for and respond to outbreaks. So some of these conditions also show that, for example, that people living in densely populated areas may find it more difficult to practice prevention measures such as social distancing. And research also showed that racial residential segregation was a fundamental cause of health disparities. And you also saw that that racial residential segregation was linked with a variety of adverse health outcomes and underlying health conditions, And so these underlying conditions also helped increase the likelihood of severe illness relating to COVID-19. What was also interesting was that critical workers who were impacted, the lack of having sick leave available, and also other underlying health conditions that could impact lower access to healthcare. Okay, just wanted to pause right now and see if there's any specific types of questions that anybody may have.
Questions? Okay, it doesn't seem like there's so many questions so far.
Okay, no worries. I'll just keep going. And so in terms of looking at the frameworks for environmental justice, there's four kind of main frameworks that we look at. These include distributive justice, procedural justice, corrective justice, and social justice. So these four frameworks may provide an analytical framework for really considering how environmental justice concerns are met, and also about trying to have early investment in these areas. So when you look at distributive justice, this is about the demographics of the neighborhood or the value of the class issues that may determine whether or not the Environmental Protection Agency is going to decide to clean it up. From the perspective of procedural justice, the idea is that is the Environmental Protection Agency going to commit to being involved in the neighborhood in the cleanup, and what should that process look like? Number three is corrective justice, is that if the contamination was caused by two young children, for example, that were living in subsidized housing, would there be an effective way to actually clean up this environmental contamination, or could there be other subsequent types of efforts by the EPA to try to recover the cleanup costs, or could they do some type of compensation to the victims? Then when you look at social justice is that instead of simply cleaning up a contaminated house, the EPA may decide it would be much better or cheaper to actually move the family to a mobile home on the edge of town, or would it be better for the social implications for leaving a contaminated property within a residential neighborhood? So those are some of the issues that are considered and also looked at as well. And so you can also see the impacts that could occur for relocated families, as well as considering the losses that would occur in terms of access to schools, workplaces, public transportation, family ties, and childcare. Another case that had developed a lot of controversy as well, which is also an interesting case, was a case involving Johnson & Johnson, which is a large multinational company. You probably may have seen products of it for different types of cosmetics. And so in this instance, the product that was the center of controversy included the talc powder, the baby powder that's also used. And so what's interesting is that there was a cancer risk associated with this powder. And so there had been a lawsuit that was brought against the company because of that. And so some of the roots of this in the US in terms of the early case law that led to the development of these issues was the Arlington Heights case. And so it's important to see kind of how the case law develops over time. And so even though the cases may be different, essentially the principles are similar. And so for Arlington Heights, environmental looking aside from the environmental context, these lawsuits can also show you, for example, that there was development in terms of these cases. And so prior to the case of Arlington Heights, there was a case known as Washington versus Davis, which looked at equal protection could be considered to be determined by a proof of discriminatory intent. And so you saw the development of these types of five factors that the court considered in terms of making sure there was circumstantial evidence of discriminatory intent. And so over the years, the five factors have really been described, but for kind of purposes of simplicity, these are the five factors. And so the impact of official action, this stems from a case from 1886, which is one of my favorite Supreme Court cases involving Yickwo versus Hopkins. This is a case involving the city of San Francisco, which implemented a new permitting ordinance by requiring the closure of all 100% of Chinese-owned laundries, but there was only about 240 Chinese-owned laundries and only one non-Chinese laundry. And so the Supreme Court found that the extreme impacts of the case of the legislation showed the evidence of discriminatory intent. And so the other factor that the courts look at is historical background. And so the racist history is also a local area, and the local area could also be considered as indicative of continuing discriminatory intent. And a case that brought this up later on was a case known as Richmond versus Crossan. And so there had been plenty of reason to believe that there was discrimination against Black construction contractors in Richmond, Virginia. However, there was absolutely no evidence of past discrimination against Spanish-speaking Asian or Indian, Eskimo, or Aleutian persons in the Richmond construction industry. So how this was happening was also taken into account. The next main factor is a clear pattern with unexplainable on grounds other than race. And so in the case of Rogers versus Lodge, a 1982 case, the civil rights plaintiff challenged those at-large elections instead of district elections in Burke County, Georgia. And the Supreme Court also found a clear pattern of discrimination that was indicated by the fact that there was no Black had ever been elected to the Burke County Commission. And their number 4 is basically a departure from the normal procedural sequence. And so a departure from the normal procedural sequence occurred in the case of Gomillion versus Lightfoot, which is a 1960 case. And so this was the city of Tuskegee, Alabama, which changed its city boundaries from a square to a 28-sided figure. So basically the city had the boundaries were the shape of a square, but basically to make it fit so that they could have the election results that they wanted, they basically made the shape of the city 28-sided figure. And this was done to exclude Black residents from voting in city elections. And so the court found that there was no legit.
Nadia, there's a question.
Yes.
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 You are familiar, ma'am, with Nadia, with gerrymandering, right?
Yes.
Is this similar?
Yes. Yes. So this was basically an example of gerrymandering with land use perspective.
Yeah. Nadia's involved with the Democratic Party, so she's very well aware of gerrymandering.
Oh, I see.
So
And the other cases,
we-
ma'am, we were discussing are civil rights cases that are related to constitutional rights of the people. Is that the
yes.
gist? Oh, that's why you're
Yes. And so
talking nation. And
yes. And so
yes, please proceed, ma'am.
no, please go ahead. Ask your question. Sorry.
I was just trying to clarify whether these cases involve the interpretation of the American Constitution. Is it?
Yes. So what these cases we're looking at were principles relating to to civil rights and specifically how they impacted land use development. And so for this particular case, they were looking at how they were going to be impacting the rights associated with the development of the city boundaries.
Dodi works at the Philippines Parliament, by the way, and so that's why he's interested in this side of this.
Pleased to meet
Yeah,
you.
and I think it's interesting also because there's concerns about like the historical trajectory and impact that these cases have. And so I wanted to show is that that even in the US there's like this that there is a robust history, but the way that it actually ends up being implemented is still it still remains to be seen. So even in the earlier cases that I had shared with you, involving the pipeline cases, even though there's laws relating to environmental protection, there's always ways for workarounds for them for industry, especially if they want to move a project forward. Thank you. And so the next kind of main point that I wanted to bring up, which is the final one, which is about the specific
Nadia,
type of
Nadia, there's another question.
oh,
Sorry,
sure.
sorry, Nadia. Just a
No.
question on the Arlington Heights case. I
Mhm.
noticed this is a very old case, 1977. Is the same standard set by this case when it comes to discriminatory intent, the same standard still being used in the US today? And does that remain adequate as of 2025, given that this case has been decided 1977?
So what happens in particularly in for cases it involves this issues of stare decisis, and so these older cases take precedent, but what you do see happening is that there will be case law that will be brought in, and so this the actual case itself, the Village of Arlington Heights, is still considered what we call in good law, but there are efforts to kind of to whittle away these rights that were enacted within Arlington Heights case. And then I'm going to show you on the next slide the reason why that the protections, even those that were offered in Arlington Heights, are not sufficient, and why there was another piece of another case law that actually removed some of those rights that were brought up in Arlington Heights. So that's an important question. And so some of those contemporary statements that are also taken into account include if the government action is also backed by some type of facially discriminatory conduct. And so in the case of Hunter versus Underwood, which is a 1985 case, Justice Rehnquist observed that the Alabama Constitution of 1901 demonstrated a zeal for white supremacy run rampant. And so a lot of these public statements had been used. So for example, when you had the case involving Trump versus Washington, which is a 2017 case. At the time, Donald Trump had called for a total and complete shutdown of Muslims from entering the United States. And so those statements were used by the courts to demonstrate the discriminatory intent behind the president's so-called travel ban. But then later on, after 3 iterations, the travel ban was held to be constitutional. And I'll show you why even though despite these protections, there's still issues with these issues of civil rights and human rights. And so, especially in the context of environmental law, and that's because of a 1981 Supreme Court case, which is the Sea Clamors case. And so the Sea Clamors case set a really powerful precedent, opposing claims that could be brought on grounds or what are called Section 1983 claims. And so here you had a case involving water pollution as well as an applicable environmental statute, which was the Safe Drinking Water Act. And so what the Sixth Circuit had done in this case is that they showed that there was full compliance with the Clean Water Act's regulations, and they would not be able to ensure full compliance with applicable constitutional laws. And so because of that, the Sixth Circuit didn't actually have a clear answer on those issues. And so what the court concluded is that the Clean Water Act claims were actually precluded under Section 1983 claims, even though the plaintiffs claimed and C claimers clearly exceeded relief that was available under the Clean Water Act. And this was a period where you had a conservative Supreme Court at the time, which is similar to the composition of it now in the United States. And so one of the explanations was that the Supreme Court did not perceive injury to the constitutional rights in sea clammers. And this, for example, would be the possibility of taking fish in the future may not rise to the property right protection by due process. And so one of the things to also kind of recognize is that there has to also be a need to show the disparate state funding that has also led to discriminatory impact. And the other part of it is the Title VI complaints. And so the Title VI complaints have actually experienced and if you've maybe been following some of this in the news, have been experiencing quite a number of losses in the federal courts. And the EPA is also dependent upon the administration that is in power in terms of how they're going to be enforcing specific types of environmental laws as well. And so you can also see that the 1983 claims, these include the filing of civil complaints in federal court that would essentially try to motivate a state government to seek a negotiated settlement. A claim under 1983 may not necessarily require proof of discriminatory intent, as they may be supported by violations of other types of constitutional rights. And so one of the things, for example, that I've, especially in the work relating to environmental justice right now, is that there's a whittling away of rights relating to environmental justice, but there's still other types of claims that can be brought forward. And those, for example, may be nuisance claims. So I think it requires more creativity within legislation as well as litigation. There could be lawsuits relating to takings, procedural process, as well as the right to contract. And so these types of civil claims, you'll also see these types of issues happening. And so there's also, and as some of you have just kind of raised, there's also kind of critiques as well of these issues. The EPA attorney, who may be based in the nation's capital, doesn't really have an idea of the community's demographics and its concerns, and also showing that the EPA attorney in Chicago may not be aware of what's happening in the state of Minnesota, and may kind of not be able to see, not have within the jurisdiction state environmental statutes as well. And so this is some of the issues that are also created, is that kind of this back and forth between state law and federal law that's also happening, and also seeing the gravity of the harm that is occurring. I wanted to pause again if anybody had any questions.
I have a question, ma'am.
Yes,
The EPA is the Environmental Protection Agency, right, ma'am? Are you
correct.
okay? Now, this office, do they have state offices on the field, or do they have their just one office in Washington, D.C.?
So they have field offices. They also have specific regional offices, also that they have spread out. But for example, like the regional office would be the national office would be in Washington D.C., and in the example I gave you, the regional office would be in Chicago. Chicago, but the region that would be covered would include the state of Minnesota, and there may not necessarily be an EPA office within proximity to that. There may be an EPA office in Minneapolis, but there may not be an EPA office in Richfield where this issue may occur.
Yes.
Okay, thank you. Yeah, I think that's helpful with thinking about the implementation of this issue. And so, and also thinking about the gravity of harm that could happen. And so next I wanted to kind of turn to issues of
There's another,
environment. Yes.
there's another question. Yes, Kitty.
Hello, ma'am. Good afternoon. I would just like to ask, what is the EPA's position right now? When President Trump reversed some of the environmental laws implemented in the US.
So the EPA right now is taken more of a of a like what was known as America First stance, in the sense that they wanted to do more energy production and put these economic issues first. So I think though what's interesting is though this puts the environmental issues like as less important than the energy production issues. And so these next few case studies I'll show you is that it's not always clear in terms of how individual cases those actions will turn. Like the courts may put more emphasis on development of energy production, but also I think it's important to also recognize globally what happens. And if you looked at the article that I had about Maskoff, much of the energy production that occurs, it happens in the U.S. It essentially leads to a high level of environmental protection laws in the US. So the US has clean air, clean water, but both marginalized communities in the US, as well as those where the US is extracting oil and gas, don't have those same protections. So it's also important to kind of think about the overall like global scale of the US's environmental rights. So let me go back one slide too. So for example, like I have wind turbines here. Many of the critical minerals that are developed for critical minerals also come from economies that aren't as developed as the United States. It also don't have the same environmental protections, and so you see communities that are going to be facing injustices and other types of concerns relating to the extraction and mining efforts, which I won't get into as much in this talk, but I'd be happy to answer specific questions about it. So one of the cases that includes environmental protection includes the oil and gas wells that have been set up all across Los Angeles. Los Angeles is a major city within the United States, but what the concern is that you will see is that all across the area it has the highest concentration of what are known as urban oil wells. And so they're actually camouflaged really well because this has been happening since the 1960s. And so the development in the city grew even as these oil well sites had been set up. About close to 600,000 people live within a quarter mile of an active oil well in Los Angeles. And so if you look on the back of this picture here, you can see this is actually an oil well right here, right against a playground site. And so this has led to a lot of resistance movements as well that I think are continuing to happen. And so every time it's kind of a pendulum that you see happening with different types of resistance activities. So this was the Keystone XL pipeline, which had been shut down, but now there's an effort to develop it. And so what I would also say is that the courts are not the ones that are really developing these rights. These rights are really developing as a result of people in grassroots organizing and activism. And this is also from the earlier protest I had shown you for Minnesota's Line 3. And I think what's also interesting to see is that there is an energy transition that is happening within the United States. And I think there has been a move away from coal towards natural gas as a natural factor, but now you're seeing the U.S. Go towards more of a regression factors and seeing more trying to revamp coal, even though the market and the utilities of scale are not there. And in fact, a few months ago, there was more development of renewable projects. And I think one of the reasons why it's important for the U.S. to develop renewable projects is because when it's a large consumer of energy, and so it doesn't also always produce the amount of energy it completely needs. So then it relies on oil and gas from other parts of the world, and so this has larger impacts in terms of its extractive economy, and also seeing kind of where oil and gas fits into the larger picture in the global economy, and seeing that the changes that are expected to happen by 2040, and some of these figures in terms of development of other renewables may change because of the policy changes that are happening in the US, but also thinking that some of the changes for other renewables may not be realistic in the short term. This is actually a grid of the United States's energy grid, and there's regional interconnects that you will also be able to see as well in this figure. And so it's not just one state can be able to make the changes; it has to be part of a larger grid system also. And so the problem is that the where you have the concentration of renewable energy resources like wind is not actually where you have the population centers, which are along the coastal regions over here, whereas many of the wind resources are located and concentrated in the central part where there's lower population. And so what that actually requires is construction of large transmission lines, and that's not always an easy thing to do, especially when you have to also take into account the regional infrastructure grid. And so next I'll pause again for questions, and then I'll share with you a case study.
Yes? No questions so far? Okay.
Okay, thank you. So next I wanted to give you, and this kind of shows you more of a local issue. So this case involves the Trinchera Ranch, and so at the time, this was the largest residential transaction in the
There-
U.S.
There is one question, Nadia.
Okay, sure, please go ahead.
Hi, Nadia.
Yes,
Can you hear me?
yes, please go ahead.
Yeah, actually, my question is about your slide referring to the environmental justice and energy production.
Mhm.
Would you be able to entertain my question?
Yes, please go ahead.
Yeah. What are the specific parameters of environmental justice and energy productions that you may refer to a specific environmental justice? Sorry. What are the things that you're trying to to share to us about the environmental justice and energy production and wind wind energy?
So I think one of the things to recognize for wind energy, there's some concerns with energy siting in terms of the communities that will be impacted, in terms of where the wind turbines will be put in place, which communities would be able to develop royalties from it. There may be impacts, for example, to biodiversity, wildlife, or different types of avian species that may actually have some birds that will fly into the wind turbines, what those impacts would be. And also on the land use impacts, if there's any types of commercial or tourism activities that are impacted by this. For example, in some of, and I don't really go into this, but just because you asked. So for example, there was a wind farm that was developed off the coast of Nantucket. And so this was primarily a wealthy community, and they were generally in favor of wind production, but they didn't want to have it because it would impact it would impact some of their recreational activities. So when they would go out either boating or yachting, they didn't want to have the wind turbine in the offshore ocean. They didn't want to have that basically impacting their aesthetics. So some issues that you will have, even if you want to have clean energy development, there will be some aesthetic issues that could impact the community, and there could be community expectations that also have to be considered. But if you look, for example, in this example here with with uh, with Los Angeles, the communities that were most impacted tended to be poor communities or from racialized minorities. In Los Angeles is where these oil and gas wells were sited. In the Keystone XL pipeline protests also involved Native American communities who were also primarily impacted in those situations. And so in this example here that I wanted to share with you, this shows you where you have economic interest against a broader concern for energy access to energy access relating to a larger group of people. So in this case here, you have a single individual, Louis Bacon, who was a hedge fund manager from New York, who bought property in an area in Colorado. And at the time, it was the largest residential residential real estate transaction. And so what you would also see is that this case basically pitted these large utility companies against him and the Forbes family, because they bought the property from the Forbes family. And I'll show you a map of the parcel. And so here, what had happened is that these were two adjacent lots, and so he basically bought them for himself, like somebody who had multiple homes, just an area that he could use to go hunting, fishing, and enjoy. And so the area was that is right after he had actually bought the property, even though there was an easement on the property when he bought an energy easement, they got approval, regulatory approval, the utility companies did, to put forward this large utility easement of 140 miles. He was not happy because this would impact his aesthetic view shed. He said that when he was sitting in his house and he looked out over the mountains, then he would see this large utility utility power lines, and he was not happy about that. And so that's what the lawsuit ensued. And so, Louis Bacon, even though when you have utility companies going against a single landowner, the utility companies are usually going to be successful. But Louis Bacon wasn't an ordinary person to go up against because he had quite a bit of resources. And so he spent quite a bit of his resources in terms of fighting not just a case in the court of law where he had filed lawsuits, but he also filed basically a case in the court of public opinion. He brought forward like a large media campaign. Also, he published editorials in the Denver Post about it. And he also had hired experts to show that in fact what was being put forward as a clean energy power line was actually using coal and not clean coal. So that was an issue that also what was important to consider at the time. And so just if you wanted to have a show of hands, or if you're on Zoom, if you wanted to give a thumbs up or a thumbs down, who thinks that Louis Bacon won, if you wanted to raise your hand?
Before we go to that, Nadia, may I ask
Yes, sure.
proceed with the thumbs up or thumbs down? I just
Okay.
would like to know, because I'm not familiar. I assume that the others are not familiar with American law. Um, isn't it that when a land is bought by a buyer and there is an easement that burdens that property, isn't it that he is also bound by that contract? Or is it in the contract? Or is he bound to respect that? Or was he, in this particular situation, was he basing his suit or cause of action on something else and not the contract?
So essentially, he was arguing under like the simple easement law for relating to property, but he was also arguing for his aesthetic view shed. He was saying that it was going to impact the way like his use and enjoyment of the property, which also is showing that the property is coming up as a nuisance law as well. So he was looking at the contractual obligations of the easement, but then also bringing up the nuisance aspect also. And I also think like
So he's bringing up alternative causes of action? Is that the idea? Or those?
yeah, so he
Yes, please proceed.
so I think that like the reason I was bringing it up is to show that he brought in alternate like an alternate theory of the case to show that it's not he just isn't just a simple contractual issue. He was saying that there was biodiversity claims as well, that there could be impacts relating to his own use of the property. So it was essentially, even though it was an energy land use issue, it essentially became a property rights issue.
That's right,
And I
because he
think
was claiming that it impacted on his like aesthetic. Uh, was there a mention of the law on which he grounds that theory that there was a violation of his? Is there a right on aesthetics in American law?
so there isn't like a constitutional right per se, but
Okay,
there's rights relating to the use and enjoyment of property.
okay. So he,
So for
yeah. So based on that, he is now trying to stretch that the meaning of that phrase, right? On his right to,
yes.
I see. So, and it's up to the Supreme Court, of course, or the courts to determine the meaning of that phrase. To include, he would like to have that included the property right of having a fine view or a unobstructed view.
Yes.
Thank you, Nadia.
Thank you. So so thank you for the question. Next I wanted to ask for like a show of hands. If you raise your hand if you think that Louis Bacon won the lawsuit.
What was the question, ma'am?
Raise your hand for the lawsuit in terms of the case. Who thinks that Louis Bacon won? If you want to raise your hand.
we
Okay.
we
I
have
raised
we have
my
two
injured
hands raised here in class.
Okay.
I think Alex sort of is thinking about it. No, he's not
Okay.
sure.
And then okay, and we also have, I think it was one hand raised online. And then who thinks that that the utility companies won this case?
No. Who thinks the utility company won? We have most of the hands raised in class thinking the utility company won.
Wait, before you
Okay.
Nadia, the result, I just would like to say that if we lose, the one who said that he won, if we lose, it does not mean we're wrong. Maybe outnumbered only by the members of the court.
Okay. No, and so the reason I brought this case up is to show you that it's not always clear cut who is going to win, because even though the rights were more favorable on the utility side, Louis Bacon actually was able to win. And the reason why he was able to win is because he had a lot of resources that he had used in the case. And so what I also think is important is that, you know, he was like a billionaire hedge fund manager. And not only did he win the case, he spent about, and I didn't tell you this earlier, but he spent $10 million fighting this case. And he had, you know, the property he had brought was like over $170 million, which is over, like at the time, the largest residential real estate transaction in the US history in 2007. And so the reason I bring up this case is because not only did he spend $10 million to fight the case, but then what he did is he converted the property into a conservation easement. So then he actually ended up getting a tax credit of $10 million for that. So basically he is a billionaire, so he was able to recover the funding that he had put in fighting to it. And then there was also a very positive press release that was
Yeah,
put out by the federal
yeah.
government.
Question.
Yes.
The $10 million,
Mhm.
is it 10 million?
Yes.
How much did the lawyers get?
So most of it was a combination of the lawyers and the media firm. So he also hired a PR firm to also handle the press as well. So he didn't just spend the money on the lawyers; he also spent the money on public relations. And so I think that was important, is that not only did he have was able to get the court on his side, but also the public opinion. And so that also is what swayed the court. So even though there's a sense of, you know, justice and neutrality, when the public opinion is favorable on one side, that also has a sway also. And so a spokesperson from the U.S. Fish and Wildlife had said that thanks to the generosity of Louis Bacon, this land is now poised to be conserved and protected from future development, establishing continuing between public lands to the north and privately held conserved lands to the south. And so really he was able to be successful because he really understood the system and how to get it to work to his advantage. So these are some of the legal concepts that were also brought up as well. And so one of them is that property is the material foundation for creating and maintaining the proper social order and a private basis for the public good. And there also is a sense that the individual human is inherently social being, dependent on others not only to thrive, but also to survive. Okay, and then I wanted to pause if any folks had other questions about that particular case and then turn over to the next case.
Any questions? I can tell you that there were significant gasps and awes, and people are just surprised at his business acumen. Yes, Alex, did you want to say something?
Well, it's great to know that it's not only the Philippines where money and power has influence. It could also happen in first world countries like the United States. Very interesting case on Louis Bacon. So thank you for that, Nadia.
we
was-
don't have
Thank you.
Wax sitting here, but I'm sure he probably has something to say about Palawan as well, because there's so many private islands that are islands that are being privatized now by this one investor.
Nadia, on the decision, who made the decision? Which court, ma'am? The United States Supreme Court?
So this was a state court case. It didn't even get to the higher level. It was a state court case.
State of California, is it?
No, oh, sorry, state of Colorado.
Colorado. It was not appealed anymore to or does the Supreme Court have no jurisdiction?
That was a Supreme Court in Colorado.
Not the federal Supreme Court. But could that case be brought to the Supreme Court of the United States?
They could. Yeah, I think they could have appealed it further, but because it had to deal with state law, there wasn't jurisdiction at the federal court.
There was no jurisdiction. The Supreme Court has
Correct.
the United States has no jurisdiction. Thank you very much, ma'am.
Okay, so then going on to the next case. So this involves the state of Wyoming. And this was a project that involved wind farm development. And so, before I forget to mention, so this was something that I had started to look at about 12 years ago, is the issues of how billionaires would have more rights than the ordinary person, and how they could also impact policy. So a lot of times a single individual can have a lot of sway over development and policy that happens, which was also the case here. And so in the previous case that I showed you, you had a single individual able to stop an energy project that would actually provide energy access to tens of thousands of people because they didn't like the way that it looked on their property. And here in this case, you're going to have the opposite impact where a billionaire is able to move forward a large renewable energy project across multiple states to be able to provide renewable energy. And so in Carbon County, Wyoming, which is primarily it's very largely farmland and cattle ranch primarily, as well as a lot of oil and gas production. And so the community expectations in the area were also significant, is that they were not used to renewable energy. They didn't like having new projects in their area. So there was quite a bit of local resistance to the wind energy development farm, which was brought forward by Phil Anschutz, as another billionaire in Colorado. And his family primarily had made money off of fossil fuel extraction. So part of the family wanted to also improve the image and be part of the renewable energy projects. And so this was where the impetus for this had developed. And another thing to note is that this county here, Carbon County, had a really high quality wind farm. Wind that was available in terms of like the speed and the velocity and the area where the wind was. And so it really was ideal for making a wind farm. But the problem is that there's very low population in the area. So the wind would have to be transported several states to be able to reach where the energy markets were. The area that you would see is that this is where the wind farm would be located in Carbon County, Wyoming. And then the hope was to transfer it down to Las Vegas. What was interesting is that the connection over to Las Vegas was less likely to was only done if they could actually connect to the California market, because the California market had strong incentives for renewable energy. And so there wasn't even certainty at the time that they would be able to connect it to the California markets, but just to hope that if they got the power line to Las Vegas, they could then go further into the California markets as well. And so this was a 725-mile transmission line that had been put forward. And then also notice that this power line, it goes through several states. So it goes through Wyoming, it goes through Colorado, it goes through Utah, and also Nevada. So all of these states that it's going to, they're not necessarily all benefiting from it. So you have about 4 states that the power line will go through that are only going to get royalties, even though they're going to have the power line in their state. And so for this particular situation, it was able to be successful, primarily because there was quite a bit of there was a consultation period that had happened with the communities, including, and I'll show you, go back one slide. And so the other thing that's interesting is that in Carbon County, the property doesn't follow a simple boundaries. Because this property had been developed by the U.S. and taken from Native Americans, they had to provide property rights, and so they essentially had a checkerboard pattern. So you have parcels that are owned by the federal government, parcels that are owned by the state governments, parcels that are owned by local landowners, and then parcels that are owned by Native American tribes. And so this checkerboard pattern was interesting because it meant that they had to get a lot of these easement rights from multiple people. So thinking about getting this easement right against one person, which was Louis Bacon in the previous case, and they weren't able to get it. Whereas in here, they were able to go 700 miles and be able to get it because they went through this extensive consultation process. So I wanted to open it up and see if there's other specific questions.
Any other questions? None so far? Okay.
Ma'am, just
Dodi
a
has a
clarification
question,
because I
yes.
was trying to understand what was the main issue in this particular case, Nadia, the last one.
So in the last case, the main issue was about being able to was about how they were actually going to be able to obtain these easements, as they have to go through a consultation process with each of the individual property owners to be able to develop it.
So the issue was the process, right? Would that
Yes.
as to how to go about
Yes.
it? Yes.
Yeah, and so the issue was less about the court cases because they actually went through the process, and they expended, I would say, around $400 million to get approval for that. And it took them about 11 years to do that. So it was only last summer that they got approval for that project.
And now the process has been established. It has been
Yeah.
meaning delineated or identified.
Yes, but the problem is that that doesn't mean that it's going to make it easier next time. It just shows that there's a way to do it. But it doesn't necessarily mean that like it's been like codified to allow for that to happen.
Codification by law, right?
Yes.
By state law or by administrative law? Would administrative law suffice or suffice?
Yeah. So it would be for like the administrative process essentially, but there may be some permitting issues for statutory procedures that also had to be followed.
Thank you very much.
Any other questions? No? Okay. Nadia, you're good to go.
Okay, thank you. So then I wanted to touch upon the law review article that I had written. About the coloniality of environmental justice. So this project that they started when I was in college, when I'd taken a rhetoric class and read about the Philippine revolution. And so in that instance, really, I was kind of interested to see how the dynamics between the Spanish colonial government were similar to those that kind of were at play at the time in the US, and kind of how thinking about the US and its global reach. And so Jose Rizal had a quote that kind of struck out to me, and that was that justice is the more foremost virtue of the civilizing races, and it subdues the barbarous nations, while injustice arouses the weakest. And so even though Jose Rizal was not looking at environmental justice, I think that his idea of having this idea between barbarous nations and the weakest ones was also kind of showing this dichotomy between those who are in power and those who don't have power. And so I think that also shows you the background that occurs between the corporate form and the environment. And so you have the barbarous elite who are also kind of concerned with the interests of the corporation, while the masses or the weakest are kind of concerned about issues of sovereignty, survival, and self determination. So what I did is I looked at 3 specific case studies involving Puerto Rico, Pakistan, and the Philippines to see how and why there's difficulty in achieving environmental justice, to achieve equality, as well as to correct environmental imbalances in the built world. So all of these places also served specifically were kind of strategic geopolitical interest that housed significant U.S. military installations. Historically, and they were also subjected to colonial domination, and so the environmental issues also brought up and were also part of these part of a broader pattern relating to colonial socio-legal apparatus to kind of strip individuals and communities of environmental rights when basic human dignity would be an issue. And so I think a helpful theorist for looking at these issues was Annabelle Quijano, who has passed away a few years back. And so he said that the model of power that is globally hegemonic today presupposes an element of coloniality. And so he says is that when you think about the colonial construct and the lives and the well-being of communities of color, the poor and indigenous groups, it really stands in the way of capital accumulation of the elite. And it also impacts how those are going to be subordinated and sacrificed. And so so in a kind of juxtaposition to that, you think about, what is the international legal framework for that? So in the idea of disaster resilience, you have the Sendai framework that was built up in the aftermath of the 2004 Indian tsunami earthquake. And so there's also a kind of an awareness between north-south dynamics as well as south-south hierarchies in trying to address environmental rights and seeing how that's going to play out. And so on one side, what Quijano says is that colonialism created the convergence of two axes of powers, which was the codification of the differences between the conquerors and the conquered. So it brought out this idea of a race, as well as a supposedly different biological structure that placed some in a natural situation of inferiority to others. And so a new structure of the control of labor and its resources and products was also brought forward. And prior to the colonization of America, the concept of race did not exist, but race would also become the modality to grant legitimacy to the relations and the domination imposed by the conquest. And the conquest of America was the point that race emerged as a position to set forward ranks, places, and roles in the new society's structure of power. And so only once race is recognized as a means of subordination can the next phase begin. And so that's what I say is the phase of environmental subordination. And I also think it's important to kind of see is when the first slide I showed you dealt with the protest in Warren County, North Carolina, but it also shows you that this is the result of centuries of environmental denigration, pollution, and toxicity in communities that also carry the burden of capital enterprise through the loss of their lands, livelihoods, and lives, while the elite also benefit from these toils. And these environmental disparities, at least since Christopher Columbus's maiden voyage, can't be accurately traced or quantified. But I think it's important to kind of see that there was harm that was done through the process of discovery by Columbus, and also recognizing that there's also a sense of exactly how investments and financial agreements are made between countries under the guise of promises of jobs and infrastructure projects, but they also leave cycles of debt and dependency on financial structures that really worsen living condition and health conditions and don't always bring the promise of improvement that they seek to offer. So I think it's also important to kind of recognize that there's pollution and chemical contamination and toxicity are also really important parts of these. And I think also the idea of environmental justice is also a bit problematic because with environmental justice, it basically means that the rights that everybody else has for environmental rights are not given to the rest of society. And so now you have to create another set of environmental rights to offer those same sets of rights as well. Environmental justice really, I would say, is, as it's like kind of currently construed, is really the state's really gratuitous attempt at environmental protection. So poor people, people of color, and indigenous groups just have the same rights as the rest of society. And so these groups essentially need another layer of rights, and another set of hurdles to access rights that are available to everyone else. And so in the US, there was work that was being done towards the development of an environmental justice act. So in 2017, during the first Trump administration, Trump was, like he is in the process now of passing a tax reform bill. And so at the time, I had gotten together with one of my colleagues, and we had the American Bar Association issue policy in support of environmental justice, which they normally would not have done. They normally would not have supported an environmental justice policy because it's less favorable to corporate interest. But they did it because it was kind of like a period of political uncertainty, and so it was basically something that we were able to get them to achieve, showing that, you know, this was an important issue. There was also a bill that was introduced at the time by Senator Cory Booker in the U.S. Senate, and there's a companion bill by Representative Raul Ruiz in the House. And so those law, as it was introduced, the ABA as the national as the largest bar association in the U.S. voluntary bar association, was able to kind of stand behind it, and so that was really kind of a moment that we were able to build policy. And so my colleague that I was with at the time, Scott Badenoch, when we were lobbying on the Hill for this, he told me that the tax bill that Trump was putting forward wasn't going to pass, and he was basically traveling between DC and California at the time. And California is a more, like, would call it a liberal state. And I was coming from Florida, which is a more conservative state, in the home to, like, current residents of Donald Trump. So, like, I felt like I had a better sense of what was happening on the ground just because I was kind of closer to it, like, geographically. And I told him, I don't know what you're talking about. That tax bill is definitely going to pass today. I was kind of, so basically, that's how we were able to get people to endorse it. And so I even gotten my person who's now my governor and was in Congress at the time, Ron DeSantis. I got his office to say they would think about agreeing to this bill and they told us, what if we found another Republican co-sponsor? And so the other Republican co-sponsor we were going to get ended up losing his seat, so we didn't get that. But basically, that was enough for us to get other legislators behind this bill. And basically, even though the bill wasn't successful, and during the Trump administration, it had a 4% chance of passing. During the Biden administration, it had a 2% chance of passing. And the chance decreased of it passing because there was a chance it could pass. And so that made the chance go down further.
Nadia,
Yes.
yeah.
The question
I was
that
thinking, I was going to ask you about the American Bar Association. Our admission to the bar in the Philippines is by way of the Supreme Court. So the Supreme Court of the Philippines has the role of attorneys. But is it correct to say that the American Bar Association is the one who admits a lawyer to the bar? Would that be accurate?
No, because the American Bar Association is a voluntary bar association. It's each individual state admits to the bar. So in the United States, you have a process where you have to seek admission and go through the process of character fitness, and you have to make sure you're also taking the bar exam in that state, or you can take the uniform bar exam. So
So there is
I'm
a
admitted.
yeah, there is. Oh yeah, please proceed. You were admitted.
So I was admitted in Florida and I took the bar exam in Florida. And so I was admitted to practice in Florida.
What office in Florida admits lawyers to the bar?
It's the Supreme Court of Florida.
Also the Supreme Court. I
Mm.
understand.
Um,
Now, I thought, now my question will now go to the American Bar Association because, in my view, the American Bar Association is a very influential organization. But I, I found it a little bit strange when only it could not, lobby enough to have that idea of the law that you were um, trying to get past the Congress. Uh, I thought that the American Bar Association was a really, a big thing in the United States when it comes to lobbying or advocating for the passage of certain laws. Yeah.
Yes, and it is true, but the American Bar Association, even within the American Bar Association. So, for example, I was working within the section on civil rights and social justice. Then there's also a business law section. There's also a section on state and local law. And there's also a section on energy, environment, and resources. And so even though the ABA as a whole did it, even within the sections, there wasn't support behind it. So even though overall they had agreed to it, is that there's large corporate influence, I would say. And in fact, in the US, there has not been any environmental law passed at the federal level since the 60s and 70s.
Oh, thank you very much.
so do you have any questions?
Like, and so anytime there has been any environmental regulation, it's been kind of like put in as an amendment or a provision within an energy bill or something related to that or some type of budget reconciliation mechanism. And there's been some amendments that have happened to the Clean Air Act and the Clean Water Act, but there has been no environmental legislation since then. And the courts have also whittled away environmental rights in the US, and they'll continue to do so.
The future looks bleak when it comes to this, right? To this advocacy.
I think from the court's perspective, it looks bleak, but I think that's why it's more important for people powered organizing. And I think that like movement building that happens as well as campaigns. So I think one of the successful court cases which took a long time to develop was the case of Juliana versus the US, which was the 21 youth plaintiffs who brought forward a case against the US on climate action. So even though their first case wasn't successful, last summer they had the same theory of the case that was brought forward under the public trust doctrine that was successful in the state of Montana. And again, that's why the jurisdiction is important, to bring up the right jurisdiction, because it's a matter sometimes about forum shopping to get the right law.
Yeah, you mentioned about public trust doctrine. The first time I heard about it. Could you say something about that? The public.
Yeah, so the public trust doctrine is a Justinian concept from Roman law. Essentially means that the land that is available is put in public trust and needs to be protected by the government as such. And so this law has been applied to fishing rights, but here Julia Olson, who was a lawyer, she was a student at the University of California, Hastings, when she was in a constitutional law class. And that's when she first came across the concept. She decided she was then going to apply it in the environmental context. And so she developed an NGO organization called Our Children's Trust. When I was a master's student in Colorado, I also got admitted to the Colorado Bar. I was right about to start my master's program, and so I saw a newspaper article that had come out that they had filed this lawsuit, and so I emailed somebody that was cited in the article and asked them how I could get involved, and so I got in touch with Julia Olson, and she put me in touch with somebody who was working on what were known as the Hatch cases, or the earlier cases in Colorado. And so I helped write one of the memorandums for that. So that was in 2011. And it was only in 2024 that they were able to have their first successful case in Montana. So basically, they would file cases. This was similar to what had been done with the civil rights movement under through the NAACP for fair housing and for voting rights. Was they would just file multiple lawsuits in many places and try to select the most ideal locations to try to see which courts would accept and move the cases forward. And so it goes through like this process. And so I think that sometimes it's important to kind of understand the process and realize it's not just a single case, but it's like a whole slew of cases that are also part of that part of that apparatus.
You said you're also a member of the Colorado bar. My
Yes.
this which bar is difficult? Which bar exam is more difficult? The Colorado bar or
Uh,
Florida bar exams?
well, I think statistically maybe Florida bar is harder, but when I took it, I was like right out of law school at the time, whereas the other time I had to take it, I'd been practicing for about 5 years. And then the reason I took the Colorado bar is because they had implemented what was known as the uniform bar exam. And if you take the uniform bar exam at the time, you could basically practice in multiple states if you apply for the character and fitness for those other states.
Thank you very much for that, for those responses.
Yeah, and I also wanted to go back to the public trust doctrine. One of the attorneys and advocates I'd also come across during my first job as a law professor was I had met with when I was at Pace Law School in White Plains, New York, was Tony Oposa, and he was a Filipino environmental lawyer. Which some of you may be familiar with. And so he had also done really pioneering environmental work in the Philippines. And so he is also important for bringing forward children in class action lawsuits against deforestation as well. And so he had also he represented about 43 children from local villages in a class action lawsuit to stop deforestation. And so even though the lower courts initially dismissed his cases due to lack of standing, the Supreme Court of the Philippines actually reversed the ruling and recognized the legal standing of children in environmental matters. And the deforestation had been halted. And he actually had reached out to American lawyers as well. There is a listserv where he had gotten support in terms of kind of developing some of the strategy and getting more public support behind the issue to do that. So I think what's important is to see is like how a single individual lawyer can also make an impact. So whether it was Julia Olson or Tony Oposa or Cory Booker, you can see as well as that it's really about kind of raising the awareness. So even, for example, if the case isn't won, the information part of it, like you saw in the case of Louis Bacon, the billionaire hedge fund manager, you can also see that there's this broader concern that's brought forward. So then I just wanted to turn it back over to you all if you have any other questions. Otherwise, I'll just wrap up.
I just would like to inform you that there's another case about the Tanyon Strait mammals. I think that case, this is another case where it appeared like the animals have rights, but or legal standing because uh, the lawyers there won the case in the Supreme Court of the Philippines. Maybe I can supply our professor and to communicate it to you because it's again another one of those
Oposa cases.
cases.
Yes,
that-
so the Oposa cases are actually taught in the first year at law school here in the Philippines, right? To understand the concept of standing. But the Filipinos, unless the ones I've interacted with, normally don't know that the cases are actually taught at the international level, pretty much everywhere.
Yeah, and I think it's interesting because he really, I think, really was a trendsetter, because I don't think he's given credit for the work that he did, for kind of how it kind of built up to the American movement. So I think especially like right now, it's important for lawyers in the US to learn from lawyers around the world in terms of what strategies are working, because there's this idea that, oh, the US has a system of laws and rules, when in actuality it looks like it has a system of laws and rules. And so the same way I think it's been able to kind of make breakthroughs, and like where there's been some bottlenecks, I think that's something that's going to continue to happen. And so that's why I brought up that example, is to show is that even though you had the development of the public trust doctrine being used in the US, it was actually the class action lawsuits that Tony Aposa had brought forward that had that kind of provided a background for that also, or its foundation.
Just to let you know, Nadia, in the session prior to this one, we were talking about international investment law, and the concern was a lot of developing countries don't have the same abilities and don't have the same amount of scholarship when it comes to TWIL approaches to investment law. And so I think what you've done here is really enforce that it's possible even for a single individuals to do something, right?
Yeah. Yeah, I definitely think so. I think that like a single case can really turn the tide on issues, and it's really a matter of like what's going to break the dam. And I think that I also think that a lot of conflicts around the world, when they're for example, like based on specific either racial or religious or ethnic issues, are many times boilerplate environmental or natural resource issues. And so I think you have to kind of break away and see what's the root causes of these problems, that's not going to go away. So whether it's brought forward as environmental case or a property right issue, it's still it has to go through the process. And so as lawyers, you have to figure out what's the best mechanism to make your case successful. And also you can think as well about what's the process that's also going to come into place, like when you're looking at it from a management perspective as well as an investment perspective as well, like what strategies are you going to bring in, whether what type of business acumen or legal acumen are you going to bring in to make the case successful. And I think that is something that you have to be able to do. Like you can't just think, okay, the tide is too high, the forces are too big. You really have to kind of think, okay, what's the strategy here? How can I best maneuver around it?
And just so you know, Nadia, we have a number of people from the energy industry here in the room as well. Are there any takeaways for them? We have some people who act as mediators as well. I think Alex also acts as a mediator, right, Alex? Arbitrator, yes. Alex is an arbitrator, and so is AJ. And they arbitrate energy and construction disputes. Any takeaways that you have for them too?
Yeah, I mean, I think it's important to think about that like energy is essential. Like we need it, like we need water, we need light. Like we're really for how civilization operates. I mean, you couldn't even be sitting in the classroom if you didn't have electricity. I wouldn't be able to connect with you if I didn't have power. And so that's why it's really like I think thinking about, energy as a human right also is something that has been considered. And I think also recognizing that also the impact that energy has on economics. So in parts of Africa where you had no mobile infrastructure, no phone landlines, and no utilities, you basically are bringing in mobile cell phones, and then you bring in solar panels, and immediately it changes the economic outlook of the place. And so I think that by having more reliable energy access, it is also a democratizing feature also.
Alex has a question.
Just a question, Nadia. Uh, is it correct that the doctrine espoused by Attorney Oposa in that case, the doctrine of intergenerational responsibility, as regards legal standing was an original concept? Was that not existing around the world before he came up with such a theory on legal standing?
So there was, I think there was in 1972 there was brought up the Stockholm Convention, and so the idea of sustainable development had been there, but it hadn't actually been put into practice in that way. And so the same thing is like you can have things that are up like on the shelves and books, but they are not going to unless they're actually going to be used. It's like basically it's like you have an idea that catches fire. And that's what it was, I think, for Tony Oposa, is that really he really brought forward the idea of intergenerational equity in the courtroom, in a way that hadn't been like it's kind of gone from international policy, something that was just kind of taught to really something that could actually be actualized, and implemented in the courts in real life.
Have you met Attorney Oposa, Nadia?
Yeah, so the first job that I had, he was a visiting professor, just happened to coincide with him that time.
She actually tried to connect me with him as well when I first came to the Philippines. So I was asking around because I had no contacts there, and so we weren't able to connect with him. But she was amongst he was amongst the two people that Nadia very generously connected me to. The other being Tanya Lat at UPBGC, who is a good friend now. So yeah. Any other questions? So thank you, Nadia. I think the class also wants to take a picture with you, right? So we're actually just going to crowd around your screen, and we'll send you the picture as well.
Okay.
So yeah. So it's actually around 5 a.m. where Nadia is right now, and she joined us at 3:30 a.m. Florida time. Good. Take the bigger, the one with a bigger picture. If you have also your own phone, just so that if it in case I get if you want to, sorry. Okay, sure.
I'll take my headphones off. Okay.
Well, the energy people are saying something. The energy people are crowding into one corner.
Okay.
Coincidentally, they're all the energy people are no, that's no Janie is there too, and so there you go. Hi.
Okay.
Do you want to go and take a picture there? Yeah, that's easier, right? Yeah, Candy. Yeah, that's why I was suggesting, because we did that last time. So you can, that side. It's a more personalized picture with Nadia. I don't know if I'll be getting people's way. That's this. Smile. Yeah, because Nadia can't hear you guys. That's why. Okay, done. Thank you so much, Nadia.
Okay, thank you so much. Okay, all right, thank you.
Thank you.
What's up?
Environmental.
I learned some new ideas like the public trust doctrine. I didn't know about that until today. And also I heard about the uniform bar something uniform bar where you can now be member of the yeah that one also.
So very legal takeaways, legal practice
Yes, ma'am.
related takeaways for
Legal.
you. Anyone else? Yes, KB.
Prof, I enjoyed it, and I really hope that someday the Filipino people would also be as bold as the American people in fighting for the rights on the environment and human rights as well.
Well, I mean, the thing is, you, the Oposa case, when I first found out about it, was actually through me doing. So I used to teach the University of London program, and so that's when I first found out about it, right? So it it really shows you that you're a lot more powerful than you think already as Filipinos, right? If there's a single lawyer who just has the right idea and is able to put it into practice, you can really inspire the rest of the world, right? So I mean, don't discount yourself and what you can do. And I'm sure there are many more Raposas in the Philippines, right? Not just one. And I don't mean his
I
children
think
by that. Yes, yes, Jody.
I think he has children.
He does have children. I think attorney Mario, who's our APD, also knows him. They were like batchmates, so apparently it was like a joke in their, like in their cohort that these were the kids that were taken to court. So like they're all grown up now, but that
Just
that was
want
their.
to say something about the article. I read about the trial of Rizal, and he was charged with rebellion, but actually he was convicted not of rebellion but inciting to rebellion. So that's another case.
Right, but also I didn't really get to say a lot about Nadia's advocacy outside the so she's a lot more than just a law professor. She's also been featured in Forbes 30 under 30 at one point. She has a talk, by the way, on the necessity of energy, but if you want to ever go and listen to that. Um, but uh, she is very practical. So there are a lot of human rights and environmental cases that what she will do is that if nobody else is taking them up, she will actually get law clinics in different uh, law schools to get students to start working on it. And so she has also been very successful in that and also bringing a lot of human rights cases. So she creates a lot of opportunities for her own students, but also for other people. And she's not the only one. There are actually a lot of professors. Like, this is what I like about the US and also teaching outside Asia in general, is that the professors will take on a role that is also very inspirational to the students. And it's not just about classroom teaching. Whereas in a lot of Asian jurisdictions, you just get very confined to the theory, right? So I don't know why that is. I'm I'm not sure if this is an Asian problem in general, but it's been a problem in most of the jurisdictions I've taught in. Um, yeah.
Ma'am, where did she take her master's degree?
Her master's, that's a good question. Her PhD is from Yale, but that was much later on. I mean,
Her,
she
her PhD is on what discipline?
environmental just
Li-
like environments, but it's also very scientific based. I'm
Yeah,
not that much of a science
environmental justice.
yeah, but like she actually has she's one of the few law professors I know of that will actually get into like engineering and modeling and so on. And in fact, she actually had a case just a year ago where she had these research assistants who were former US military and they stole her models. Um, and so yeah, that's a possibility. But that was not directly law related, but she's that brilliant. She's able to do that sort of stuff. But I like her first few law degrees were from good universities, but they weren't League level. But that also goes on to show that you can achieve a lot and have kids. She was very sick at one point as well. Even right now, when she was talking, her mother is in the hospital. She has terminal cancer. And yeah, so I'm constantly in awe of what she's able to do despite everything. So yeah. And her PhD at Yale also started in her 40s.
That's a rare gem.
Yeah, yeah. So what I'm trying to say is it's never too late. You can always do these things. And you she's also, I mean, I've known her for uh I found out I met her for the first time, like I told you, I went to Harvard, and that at that time I was very much it was a journey for me just to get there, even in terms of my finances and everything else that was going on. And so I was very alone when I went to that conference. And um, to the extent that, you know, these conferences can be a really difficult place to go to if people don't know. A lot of academics can be very snooty, right? And so if you, especially if you're a newbie and you're already not sure of yourself, you tend to just stay in a corner. And so I was very grateful that there were a couple of people like Nadia. Not only did she approach me, um, she also then wanted to collaborate on different things. And I don't come from an academic background. um I'm very open about the fact that, you know, my mother is a high school graduate. I come from a good family by Pakistani standards, but my mother's father passed away when she was only 9, and so she didn't have the same opportunities. And so for me as an academic, it's always been a fight to get to the next stage. And so if I hadn't met her, I wouldn't be standing here today. Like, so I think that also just goes to show you that this is, I mean, I know you're thinking you know, you guys have the same getup, so that probably helped. But I can assure you that is not the case. There are most people are actually like, even if they're Pakistani or belong to the same like faith as me, in and they're raised in the States, can be very obnoxious and very stuck up and very difficult to approach. And so it's a rare gem who can actually you know, look past that. So I'm grateful for that. And so see you all on, when is the next, is Wednesday. Yes. Yes. So see you all on Wednesday.
reflection, reflection, sorry, the
Yes.
reflection paper. It's about the presentation of Prof. Nadia, or the whole.
It's about the whole course,
Okay.
guys. It's stated several times in the reflection. I want you to reflect on the course as a whole. What are the key takeaways? And so that's what it's about. You've already received the instructions for the presentations, right? Yes, yesterday I sent them to Ivana yesterday, and she's already posted them to Alice. All the instructions for all 3 LTs, they're all different, are there. You also have the rubric at the very end. I know it's a bit long, the instructions, but it's all there. And so the other thing is, please be courteous to each other when you present. And you might have also noticed, I am fully aware that when there are group projects, there are always free riders. People who will want other people to do the work for them, which is not acceptable to me. Which is why I want to know by Tuesday who is doing what in the project. How are you dividing the tasks? So please email us and let us know by Tuesday so that I know who, how much, you're putting into this, right? And I hope to see equal participation from everybody during the presentations. So the tasks are also divided equally within your LTs. Okay? So see you all on Tuesday and Wednesday.